My lord, I appear for the.
Yes.
My lord, on 19th March, my lords have passed this order that the receiver was,
You have a copy of them. Yes.
required to execute,
Yes.
rather, and present the deed for registration. Unfortunately, his father died on 5th of April.
So you should extend the time. Till when? Tell us.
Another 3 weeks, my lord, from 17th, from 20th, my lord, from 21st, another 3 weeks.
Very well. So we'll fix a date then. Another 3 weeks means it's 13th of May. We'll make it 15th of May. 15th of May.
Great. Right.
By an order dated March 19, 2025, we had extend the time for presentation and execution of deed of conveyance for registration, execution for presentation of the deed of conveyance till a limited period, that is till April 17, 2025. Full learned counsel for the parties, in their usual fairness, submit that since the learned receiver faced a bereavement in the family in the meantime, such time be extended for 3 weeks. Accordingly, the time granted to the receiver for presenting the deed of conveyance for registration is extended till May 15, 2025. The order dated March 19, 2025 stands modified to such limited extent.
Right.
Thank you. What else?
Order 41 appeal.
Yes, yes.
Great.
Thank
you. My lord, I am mentioning this matter to leave to file the appeal without certified copy.
Why?
I have
Appellate side?
Appellate side.
Why?
I have applied, but till now I have not.
Very well. Leave is granted. Leave didn't. You have got a copy.
Yes.
To mention for hearing matter.
Hearing no.
My lord, your lordship has already passed an order in the appeal. My lord, 2 minor corrections are required in the appeal.
Please hand over. To be mentioned corrections.
May I be permitted to mention one first appeal, my lord? What has happened? Last December 2024, my lord, has passed for the preparation of the paper book, my lord. But the paper book could not be prepared because the lower court record could not be procured, my lord. I have paid the messenger cost, my lord. But in the meantime, what has happened? The interim order has expired, my lord.
Is for extension of the interim order?
Extension of the interim order, my lord. Can application I have already served upon the opposite side.
Can is pending.
The can is pending.
It's a can for extension.
Yes, my lord.
The application heading it.
May I be permitted to mention on application, my lord?
Application.
May it please the lordships, this is a matter when last week my lords had passed an order directing the registrar original side to transfer the amount.
Yes. That matter, the department said something.
Yes. So we went to the registrar. The registrar informed us that the original DD he has not encashed. It's lying with him. If an line
that order has to be modified that the cash won't be transferred, but the
cash
bank
cannot be
guarantee
transferred.
would be handed over.
He can hand over the original DD back to us, and thereretafter we can. My lord,
let it appear as to be mentioned. This is an original side matter.
This is an appellate side matter.
Oh, right.
Yes.
Later to be mentioned. It will appear as to. Please remind us when you take up the matter, and we'll just pass it.
Madam.
My lord, hearing matter, my lord, is matrimonial suit, my lord.
Forget. Yes, call on the list.
One, my lord, I'm for the appeal. And my lord, last occasion, this was substantially hard at the time of hearing. So it was detected that one of the parties died. After that, your lordship was pleased to detect this. That has been done, and LCR was called for. Now it is arrived, my lord.
Paper books have been prepared. No?
Everything, it is hard, substantially hard. At that point, it was detected.
So what about that death of? What about the death of that person?
Yes, that has been regularized.
That order has been passed.
Passed, regularized, and last occasion, your lordship was pleased to call for the LCR. That has arrived also.
The counsel for the parties submit that the matter was substantially heard when it was detected that one of the parties has died in the meantime. Next para, it is submitted that the appeal was otherwise ready for hearing even at that juncture, and the defect due to the demise of the said party has now been cured. Next para, Accordingly, let the matter, accordingly, comma, keeping in view that the matter had been substantially heard on an earlier occasion and was on the verge, and was virtually on the verge of completion, comma, let the matter be listed under the heading hearing in the monthly list of May 2025.
It would be right.
Next.
For the appellant in this matter,
Yes.
is my application for modification of the order dated 18th of March 2025. My lord,
Your Lordship, I'm appearing for the respondent. Your Lordship, I'm being led
That's-
by Mr. Mukherjee.
It was a decree, formal decree has been drawn up. What is the modification you wanting?
my lord, kindly see, your lordships were pleased to pass a decree for a sum of rupees 24,000 odd.
Your
And
Lordship, I-
there is a deposit in the company code which amounts to 12.38. My lord's order was that if we can withdraw the amount, then degree will be satisfied. That is the thing to be corrected. But that amount will be adjusted, the rest to be paid by them.
Your Lordships, I'm praying for a short Passover. Your Lordship is.
We did not say anything on that. We said the defendant respondent shall pay to the appellant a sum of rupees such and such, along with interest.
My lord. And there is a later on by addition, my lord, your lordship attention was drawn in the last portion of the order. There was some addition, my lord, after the passing of the order. Because in the company code, they have deposited a sum.
Oh, acha, acha, yes, a later order is there,
My lord, they have deposited a sum of rupees 12.38.
which will not satisfy the degree.
That
which
is
will not
nearing
satisfy-
half. That is nearing a half. So, my lord,
All right, all right.
my lord, substance is this, my lord. If we withdraw the amount from the registered original side,
Right,
and the
right.
balance amount they will pay.
We'll just check up.
That correction is nothing more.
Very well. It's a minor correction. We won't wait for him. Learned senior counsel appearing for the appellant. You are for the appellant in the matter, weren't you?
My lord, yes.
Yes. Learned senior counsel appearing for the appellant submits that in our judgment, in the later portion of our judgment dated March 18, 2025, comma, we had recorded that upon withdrawal of the amount deposited by the defendant respondent with the learned registrar original site, comma, the decree would stand satisfied. However, comma, it is submitted that only a portion of the decretal amount was actually deposited, and as such, comma, the appellant may be at liberty to proceed with the execution for the rest of the decree. Accordingly, we modify the later portion of the judgment and decree dated March 18, 2025 to the effect that the the plaintiff appellant shall be at liberty to proceed with the execution for the rest of the decree after partial satisfaction of the same by withdrawal of the amount deposited with the learned registrar original site. The portion of the said judgment whereby it was recorded that such withdrawal would be construed as sufficient satisfaction of the decree be modified to such extent.
My lord, it was 12 lakhs. My lord,
Third
will
gate.
hand over.
We have not mentioned the amount.
Well, it is
No,
mentioned-
whatever amount is there.
Well, letter is there, but 12 lakh.
No, we are not specifying the amount. Again, there will be a mistake. Again, another.
Well, kindly
We have said whatever.
stay of that bill should be extended. Otherwise,
No, no stay of, no question of stay.
Already there for
My-
4 weeks.
my lord, it will extend. Otherwise, this
We had granted a stay.
we have had the stay. My lord, order.
4 weeks. 4 weeks stay
4
was
weeks,
there.
but my lord, again
Only
the
was-
this-
Jury also did not point this out that it would not satisfy the degree.
my lord, it was by mistake. It was
No extension of stay. You have already levied execution.
No,
No,
man, what
no.
will
Then
time-
there is no execution case will take
So stay
much
still-
more time than 4 weeks.
My lord, just
Stay is
now
there,
4 weeks. It will expire within 2
Let
days.
it expire. Let them first file an execution case. They will file an execution case. You point out this.
They
No,
will
no, no.
write a letter to the registrar and they withdraw the my lord. That
They will withdraw immediately.
because the letter, money is lying with the registrar, and your lordship has done. We
We
kindly
had already passed a decree regarding the amount lying with the registrar, right? We had granted a stay regarding that. Now we have permitted them only to levy execution regarding the rest of the amount. Execution will take much time. No further stay. Call on the registrar. Yes. Yes, please.
I have informed Mr. Banerjee, my lord, he is not here, my lord.
Why is it appearing? Non-prosecution.
No. The last order, your lordship was pleased to
sorry.
stay the matrimonial suit for divorce in view of dismissal of the suit for restitution of conjugal rights with certain observation, which will ultimately affect the divorce suit pending. Your lordship stayed it for limited period up to end of March. And in the meantime, your lordship directed to put in the requisite. I have put in the requisite. The trial court record already comes.
What are you wanting now?
For extension.
The order is dated? Yes, 11th November.
11th November. Your lordship granted liberty.
No, till disposal of can 2. There shall be stay of all further proceedings. 11th of November order, we granted stay till disposal of the suit. Matrimonial suit number 43.
It's
Till disposal of can 2, sorry.
2nd of December 2024 order.
Oh.
Point number 9, your lordship will not in
By a separate application, we said. The parties will be at liberty to seek extension of the order passed by filing a separate application. We had specified in file a separate application.
Very well, I should.
Learned counsel for the appellant seeks an extension of the stay granted by the order dated December 2, 2024. However, in paragraph number 9 of the said order, we had specifically granted liberty to the parties to seek extension by filing a separate application in the event the appeal was not disposed of before March 31, 2025. Accordingly, the appellant shall file an application to that effect. Of liberty to mention the application as and when filed, for inclusion in the list. File it, mention it, immediately will include. And you'll get time also to give a copy to the other side so that they're not here today. Serve a copy of the application.
But I am for the appellant, my lord.
The appeal is against what?
Against degree of divorce. Now husband has decided to marry. He has got a girl.
So he had, you are the wife.
But I am for the husband. Wife has obtained degree of divorce. Husband has challenged that. He has realized his mistake. He want to not press this.
Very well.
But only thing, certified copy to be replaced with a Xerox certified copy.
Why?
My lord, this is required urgently because he is going to have a registration of marriage. There they want to see the original degree, and for getting original degree again from the court will take time.
Learned counsel for the appellant, on instruction, candidly admits that the husband/appellant has decided to withdraw the appeal since he has opted to go for a remarriage. Next para, for such purpose, it is submitted that the original certified copy of the impugned judgment and decree would be required, which the appellant seeks leave to replace by photocopies. Since it will take a prolonged time to obtain another certified copy, for the ends of justice, such leave is granted. Accordingly, FA 234 of 2024 is dismissed for non-prosecution without any order as to cost. Leave is granted to the appellant, through his learned advocate on record, to take back the original certified copies of the judgment and decree impugned in the appeal by replacing the same with photocopies of the same. Best of luck to both of you. All three of you. Yes. Who appeared? The lady or the gentleman? Since the relative of one of us is appearing for one of the parties, relative of one of us, bracket parties, let the matter stand released from our list on personal ground with liberty to the parties to seek an extension, to seek an assignment before different division bench. Thanks. Mr. Shork, you give him.
Hello, 6, I am for the appellant.
Yes, Mr. Banerjee.
It is
But I appear on behalf of the respondent number 1, my lord.
My lord, all the defects 7 excess section 5, my lord, the difficulty, my lord, because of the tension going on, my lord, in Murshidabad and the Malda district.
From Murshidabad?
my lord, I am
Adjunct cyanide.
adjacent because
But I'm
they have candidly, my
but
lord,
I'm opposing this prayer, my lord. My lord, if your
informed.
lordship kindly
Wait,
see the
wait,
earlier
Mr. Datta,
order.
before you oppose, let him move it.
My lord,
Let him move it.
they have candidly informed me, my lord.
No, you have not filed a Section 5
My
application.
lord, I have made it ready. Only difficulty, my lord, they are not able to come because of this situation. And my lord, and all other defects, my lord, I have already removed. Already that has.
But then, Mr. Prasad, you have to incorporate this reason, this additional reason also for the additional days.
My lord,
Prepare it afresh, because he has not yet affirmed.
yes, my lord, tomorrow I have told to come tomorrow itself to affirm the, my lord, as it is not affirm, I am only seeking, my lord, 10 days more time, my lord, because of this situation.
The other defects have been
And
cured.
yes, I have removed all other defects.
Yes, Mr. Datta, why are you opposing on what ground?
But if your lordship kindly see the earlier order for the last 2-3 years, my learned
Because
bench.
you may have three stands. One, you support the new Waqf amendment, or you are opposing that, or
No,
you
my
are
lord,
not aware of the
but
situation
but
prevailing in
it's not
Murshidabad.
connected with the present issue. It's running over. It's my lord. It's this honorable bench rooted to the Lojima bench, but they have not. It's their undertaking to file the Section 5 application long back. If your lordship kindly see that the ultimately matter has been placed before your lordship for final order. We are suffering, my lord.
Mr. Datta will not pass any order
I'm
holding
leaving
that
it to your
content.
lordship, but this is
No,
my
we'll,
submission.
but we'll say that this is the submission made by the appellant, but we are not deciding on the merits of that submission, but we'll place the matter after a fortnight. After a
Lordship,
fortnight under the same heading, Mr.
as your
Datta, under
lordship,
the same heading. If they
just by
file an
submission,
application, we'll give. If they file an application in the meantime, we'll give them liberty to mention for inclusion in the list in the meantime.
grateful.
But we are keeping it under Lojima final heading, final order heading.
Yes,
lordship.
He's not asking for more, Mr. Prasad. How can he? We cannot allow the
Lordship.
Section 5 on this.
I am only.
Learned counsel appearing for the appellant submits that in view of the current unrest prevailing in the district of Murshidabad, from where the
And also the surrounding Malota, the adjacent
Murshidabad and the surrounding
areas of
areas,
Malda.
including Malda, from where the appellant hails, the proposed application for condonation of delay in preferring the appeal could not be filed by the appellant in terms of the earlier assurance given before this court. Whose of next para, learned counsel appearing for the respondents vehemently opposes such prayer and submits and draws the court's attention to the previous order whereby it was given an impression by the appellant that it would be filed within time, filed much before. Puts up next para. However, even without entering into the merits of the submission made today, we are of the opinion that for the ends of justice, an opportunity ought to be afforded to the appellant to file his application for condonation of delay. Accordingly, the matter is adjourned for a fortnight from date and shall next be listed on April 30, 2025 under the same heading. Liberty is given to the appellant, upon service of an advance copy on the learned advocate for the respondents, to mention the application under Section 5 of the Limitation Act, as and when filed, for inclusion in the list in the meantime.
I'm getting.
Grateful, lordship.
Thank you.
But I'm giving my name in the chat box, my lord.
Yes, Mr. Datta. Mr. Prasad, but ensure that this ground is also included there because this will add up to the delay.
Yes, my lord. Today's. Yes.
Not today. I mean, this Murshidabad Malda.
Yes, yes. My lord, that ground that I have mentioned before.
Don't embellish it too much.
Yes, yes, yes. I'm getting.
Yes.
Mr. Prasad has taken the right ground now.
No, this is for only this period.
Lordship.
And you will have to satisfy us as to when the unrest started, whether it has ended,
That is a
what are the contents of the new bill, and all these things you come prepared on those also. So those will be very germane for allowing the Section 5. Next.
Item number 7, I appear for the appellant. At the outset, I extend my greetings of the new year to all.
Same to you, but anything in your matter also?
No. The matter was, my matter is this, my lord, that your lordship was kind enough to allow the substitution application as well as setting asides. There were plethoras of applications.
Oh, so amendment
And
of the
yes, and your lordship was kind enough to allow me to file a fresh memorandum of appeal, which we have done, my lord, and subject to the sanction of the
and the office report is that that is in consonance with the subject.
my lord. And what has happened is, my lord, it's very unfortunate that on the last part of that order, if you your lordship kindly takes that, your lordship was kind enough to my lord, appreciate the fact that there was a decree to be executed by the respondents, and my lord, at the page 7 of
Yes.
that your lordship's order, it was expected
Yes,
that, yes, my lord, unfortunately the opposition to this section 5 as well as the restoration application which is pending was filed on the 10th. We are on 16th today, and my lord, unfortunately they are proceeding with an execution which, as the outset I had said, my lord, they had filed a suit for recovery out of the same my lord, crux of the scheduled property. We had lost our case in the suit for declaration, and they have
Your declaration was for your title in the property.
Yes.
Title in the property was dismissed, this suit against which this appeal has been
Yes.
filed. The other suit is on the basis of their title.
Yes, on the basis of their title, they sought for recovery of possession since this dismissal was there.
What is the stage of that execution?
My lord, that execution, my lord, was, my lord, I have taken out the orders from the
Just tell us.
my lord, it is there for police help, and my lord, the SP has been directed by the learned trial court to have the entire issue, my lord, reported to the court on the next date fixed. It was,
After giving them possession.
yes, my lord, may I take your lordship?
Have you given a notice to them before
Yes,
mentioning
my lord.
this?
No, my lord. It is
In the list. It was in the
returnable today.
Oh, very well. We'll pass an order of stay right now.
My lord, may I put this on record? The last order passed by the learned trial court.
Yes.
My lord, the learned
Now
trial court
executing. Now executing.
proceeded with the fact.
Now it's the executing court, not the trial court.
Oh, my lord, I stand
Yes.
corrected. My
These
lord,
are small things, but
I stand corrected.
yes.
My lord, they are proceeding with the fact that this particular section, second appeal, pertains to another title suit, and their title suit is different.
আমরা expectation একটা observe করেছিলাম, it is expected shall not be put expectation টা should be read as a state. Anyway সেটা বলবো না, section 5 এ who urgency থাকলে we can understand.
And when, my lord, they are taking this orders into their my lord,
opposition,
not opposition, but in their execution proceeding. Kindly seize this order. A date prior to this. Hence, my lord, I had apprehended, your lordship had, my lord, joined me with this apprehension and requested my learned senior friend appearing. This is the whole issue, my lord.
The application for condonation of delay in preferring the appeal has come up before us today. First of all, at the time of call, none appears for the respondent or respondents. Although the appellants are represented through counsel. First up, learned counsel appearing for the appellant submits that the present appeal has been preferred against the dismissal of a suit filed by the appellants for declaration of title and consequential reliefs. First up, next para. However, on the strength of the said impugned decree, a different suit for recovery of possession was initiated by the respondents. Respondents 10 to 13 only.
No, my lord. All the respondents has initiated.
By the respondents.
Presently, they are, my lord.
By the respondents. First up, even on the last occasion when the matter was taken up, that is on April 29, 2020. Sorry, that is on
18th of March.
Right, March 18, 2025, when the matter was taken up for hearing, an apprehension was expressed by learned counsel for the appellants that the respondents, taking advantage of the pendency of the condonation of delay application, may put such decree into execution, thereby rendering the present appeal infructuous ab initio. First of next para. Today, at the time of call, learned counsel for the appellants hand over server copies of 2 orders, respectively bearing order number 48 dated March 21, 2025 and order number 49 dated March 24, 2025 from passed by the executing court in the other suit comma, where we find that the executing court has observed that there is no impediment to proceed with the execution case as there is no order of stay in connection with the present appeal, and that the execution case may be proceeded with in its usual course. Full stop. Next para. Since in our order dated March 18, 2025, comma, we had specifically expressed an expectation that the impugned decree shall not be executed in the meantime, taking advantage of the time granted to the respondent numbers 10 to 13 to file their affidavits in opposition, comma, we find the said attitude of the respondents as well as the executing court a bit disturbing. Full stop. Next para. And the expectation was expected only on the premise of the apprehension of the appellants and, comma, in the event time had not been sought for by the respondent numbers 10 to 13 to file their affidavit in opposition to the condonation of delay application, comma, the same might have been disposed of by now and the court might have taken up the application for stay in connection with the appeal. Full stop. Thus, comma, the respondent numbers 10 to 13, comma, apparently, comma, are taking advantage of their own wrong in seeking adjournment for filing affidavit in opposition to the condonation of delay application on the one hand and, comma, on the other, comma, proceeding with the execution case in a connected suit, comma, thereby attempting to render the present appeal infructuous. Full stop. Next para. In such view of the matter, comma, we find extreme urgency in the matter. Full stop. Also, comma, we are not unaware of the settled legal position that in case of extreme urgency, comma, even during pendency of a condonation of delay application, comma, the court's hands are not tied in grant of stay. Full stop. Accordingly, comma, in view of the manner in which the respondent numbers 10 to 13 and the executing court is proceeding in connection with the other connected suit, comma, we grant stay of all further proceedings in title execution case number 6 of 2021 pending before the learned civil judge junior division first court at Jongipur, Murshidabad till disposal of what is the section 5 application?
This section 5 application pertains to a restoration application. This appeal was dismissed for default, my lord.
What are the applications?
My lord, there are two applications pending before this honorable court. One is restoration application.
What are the numbers of section 5?
That is number
till disposal of can 2 of 2020 within bracket old can 10611 of 2010 and can 3 of 2024.
Can 2 of 2010 and can 3 of 2024. These are two applications pending before this honorable court. And my lord, they have
line at all concerned shall act on the server copy, comma, coupled with the communication of the learned advocate for the appellants for the purpose of compliance, comma, without insisting upon prior production of a certified copy.
My lord, they have filed their opposition, my lord, on the 10th. May I be leave be granted to for extension of time to file the reply to that?
In the same breath, you cannot do that too. You should have affirmed. They have affirmed beyond time.
No, yes, absolutely. They have affirmed the 9th and served beyond 10.
Since the affidavit in opposition has apparently been affirmed beyond time, comma, the time for filing reply to the same is extended for a week.
My lord, I shall.
For a week from date.
Matter to appear, my lord.
When was the matter directed to appear?
My lord, today was the returnable date of this matter.
The matter shall next be listed on April 28, 2025.
Extremely grateful.
Monday week.
Grateful. Well, let this copy be taken on record, those the orders.
Line the server copy is handed over today, be kept.
Grateful.
Yes.
Item number 9, my lord, I am the applicant. Opposing this is an application for clarification of the judgment dated 24 December 2024 in the first appeal 67 of 2012.
The application number is?
Canteen.
Canteen. What is the correction you are seeking?
Clarification.
Acha, what clarification?
Kindly come to page, running page 23. I have judgment, paragraph number 52.
52, yes.
Mallard's direction is the substituted appellant shall jointly execute a transfer deed in respect of the suit property covered by the purchase deed of late Debobroto Majumdar, original appellant dated February 15, 1990 in favor of the respondents 1A, B and C jointly within 31st January. Malad, the problem is the direction upon us is to only execute the transfer deed. Now, the problem is we will prepare the transfer deed and pay the registration cost. Before the executing court, my lord, my learned friend appeared on 27th January. And after consulting with his client, he submitted that my client will execute the transfer deed within 48 hours. Thereafter, my lord, whole scenario has been changed. And executing court passed an order on 29th. Kindly come to my lord page.
You had to execute the deed within January 31, 2025.
They have not done it.
Substituted appellants shall jointly execute a transfer deed in respect of the suit property. You are the substituted appellants. You had to execute that within 31st of January. Where is the clarification? Sorry.
That is what
Where is the need for clarification? You had the order is as clear as daylight.
Your Lordship, the whole difficulty is, Your Lordship, they have given a letter.
No, whatever. January. First, let us be convinced what is the lack of clarity there. You had to execute that deed within January 31st, 2025. If you don't do it, they'll put it to execution and do whatever they'll deposit, whatever is the process of execution, they'll put in the draft.
Letter appear before 27 before the executing.
Have you executed the title deed?
No.
You had to do it by January 31st. If you have not done it, they'll execute it. That was the judgment. Where is the lack of clarity in this?
No, my lord,
What was the doubt in your mind?
27 before executing court, my learned friend submitted that my client will execute the transfer, prepare the transfer deed within 48 hours. That's why we will not prepare the transfer deed.
You take their words as gospel truth, and now you don't follow the direction of the court. You should have just looked at this judgment and followed this. Whatever they say, how is that material even? We don't find any lack of clarity in our judgment. So there is no scope of modifying this or clarifying. What is the clarification?
Another his problem is who will pay the.
No, that is whatever the law will take its course.
Tell you, Lordship, what the difficulty is. He is not able to
They
express
will
this
not
for the
agreeable
court.
to pay the.
They have 1 second. The thing which they have not placed is a letter at page 24. They say that one of the appellant is 83 years old, staying in Delhi. She won't be able to come and execute. That is what the difficulty is. That is what their contention
No, my
is.
lord,
They're not saying that. If they don't say that.
No, Your Lordship, they have annexed a letter at page 24. That is what the letter says.
No, my lord, she
That they have
already
not-
executed
It's
power
not-
of registered power of attorney.
He's not. If she has, then she has.
Power of attorney. She is lying in bed, 83 years old.
Right.
They have to execute.
Mobile.
Power of attorney, constituted attorney is there. He's not lying in bed. So execute it. Otherwise, you execute it. You are already overdue in execute. Why didn't you execute in the meantime?
Your Lordship, we have put it before execution. Your Lordship,
Proceed with the execution.
the executing court has said that they have to execute. That's the order of 29 January.
What?
That's the order at page 32.
Learned counsel for the appellants submits that due to certain lack of clarity in the judgment dated December 24, 2024, passed in F8 67 of 2012, the same could not be carried out. So it is contended that when the matter came up before the executing court on January 27, 2025, it was given out by the decree holders stroke respondents that within 48 hours, the substituted appellants had to execute such deed of conveyance, which was contradictory to the judgment. For next para, learned counsel for the respondent submits that the stand now taken by the appellants before this court is different from that taken in the application and before the executing court, where it was submitted by the appellants that one of the substituted appellants is 83 years old and bedridden and could not sign the deed. Full stop. Para to this, learned counsel for the substituted appellant submits that such difficulty has been taken care of, since the bedridden appellant has already executed a power of attorney in favor of a person. For next para, be that as it may, we do not find any lack of clarity in the judgment in question, where it was specifically enumerated that the substituted appellants were to jointly execute a transfer deed in respect of the suit property covered by the purchase deed of late Devobroto Muzumdar, comma, the original appellant, bracket closed, dated February 15, 1999, in favor of the respondent numbers 1 small a bracket, comma, 1 small b bracket, and 1 small c bracket, jointly within January 31, 2025, comma, which shall be registered through the trial court. Since such execution has not been done, comma, as per the liberty given by us in the self-same judgment, comma, the respondents are at liberty to execute the decree. Hence, comma, we do not find any merit in the present application for clarification, for purported clarification of the judgment dated December 24, 2024, comma, as we do not find any doubt or any ambiguity in the judgment in the first place. Accordingly, Can 10 of 2025 is dismissed on contest without any orders to cost in the light of the above observations.
Only one thing, as a degree holder, only one if your lordship clarify, the difficulty which I am facing is that the registry department is saying that now I have to pay the stamp duty on the current market value. So your lordship
That
has
whatever is the law will take its course. Mr.
consideration
Banerjee, we won't pass. That is a part of the execution. You take care of that. That is beyond the scope of this appeal.
will not interfere on this. The registry department is saying that you have to pay as per the market value. So the consideration is 2,50,000.
That will be the subject matter for revision then, please. We cannot do anything on that. We cannot go beyond the appeal. Yes.
The defendant is the appellant before your lordship. And my lord, in this case, my lord, your lordship order to have the copy upon the.
They are appearing now, Mr. Bhattacharya.
I am appealing on behalf of respondent number 1A.
Plaintiff respondent.
Only except 2 or 3.
10 to 12.
10 to 12. Now, my lord, every service, my lord, but my lord, it is my duty to my lord, do your notice to your lordship that my lord, paragraph 2, there is some corrigendum, my lord, because he says that I have served the copy of the application with annexure to the garden pleader as well as the respondent. So, my lord, it is my duty to note. Your lordship, every service some mistake, my lord.
What is the mistake?
Mistake, my lord, paragraph 2, my lord, statement is
yes,
from the learned advocate, my writ petition along with the annexure, but it will be my lord, first application in connection with the appeal. Those all are served.
Writ petition, instead of writ petition, it will be application. And that's a copy paste error. We ignore that. Yes. So what you have served on all?
All.
Everybody has been served. You have checked up.
Except the private respondent, my lord, plaintiff respondent.
You are appealing for the plaintiff respondent. So what is the application for?
Application for substitution after setting aside amendment, my lord. Application, my lord, in this plaintiff dependent appellant died on 17th March.
No, one of the applications is why 2 applications?
Application number 3, my lord.
Can 3, yes.
Yes.
What is the other one? Can 2?
Can 2, my lord, probably, my lord, one application was filed by the
appropriate orders.
That is the early hearing.
For filing paper books.
I have we'll come to that later.
The paper book has already been filed.
We'll look into that. What is the cause of the delay, Mr. Bhattacharya?
Delay, my lord. Actually, he came to know from the defendant number 2.
If you precede something by saying actually, it is not actual.
No, my lord. Almost died, my lord.
Yes.
On 9/1/25, he
9 January 25.
Yes, my lord. And 17th January 25, it was filed.
So when did he die?
17th March 24.
24. So immediately after coming to know, you have filed. Yes, what do you say? Affidavit of service filed today be kept on record. Acha, Mr. Bhattacharya, you have served copies of only this application. That was the direction.
This application, because another application
could not be. Better. The affidavit of service filed today be kept on record. It appears therefrom that all the respondents have substantially been served. Heard learned counsel for the defendants appellants, and the appearing respondents, comma, who are the plaintiffs in the court below. Next para. Upon perusal of the averments made in the application, comma, we are satisfied as to the sufficiency of the explanation for the delay in filing the present application for substitution upon setting aside amendment on condonation of delay, comma, since the appellants came to know of the demise came to know about the pendency, since the surviving appellants came to know about the pendency of the instant appeal late, comma, upon which they filed the application at the earliest. Full stop. Accordingly, can 3 of 2025 is allowed, comma, thereby directing the heirs and legal representatives of the original appellant number 1.
Yes.
Namely late Noor Muhammad, comma, the particulars of which heirs have been stated in paragraph 2 of the application read with annexure A thereto, comma, in place and stead of the said deceased. Full stop. Next para, the necessary consequential amendments to the memorandum of appeal and the other connected applications shall be other pending applications shall be carried out by the learned advocate for the appellants during the course of the day. Mr. Bhattacharya, during the course of the day. Correct the memorandum and the applications, incorporate these names during the course of.
Advocate of the appellant, my lord. He is jail, my lord. Your lordship, my lord. Monday, minority.
Will give you liberty. Shall be carried out by the learned advocate appearing today on behalf of the appellants during the course of the day. Full stop. Next para. Appearing today bole namta diye din. Appearing today, namely Mr. Suprabhat Bhattacharya during the course of the day. Full stop. Next para. The appeal is accordingly treated to be otherwise ready. You have already prepared paper books.
Yes, well, I prepared.
Trial court records have arrived.
Trial court records arrived. I have already prepared the paper.
We'll seek a report from the office on that. Then we'll dispose of the other can.
Yes, sir.
Can 2 of 2014 within bracket old number can 8147 of 2014, comma, is an application for expeditious hearing of the appeal. Full stop. Learned counsel for the plaintiff's respondents submits that the trial court records have already arrived and the paper books have already been prepared and filed. Full stop. Next para. Accordingly, can 2 of 2014 is disposed of in the light of the above observations. Full stop. Next para. The office shall furnish a report as to whether the appeal is otherwise ready in all regards for hearing within a fortnight from date. Liberty to mention the appeal as and when the same is ready for hearing. Arises from a partition suit, then all have to be served. We have to wait for that report also. Yes.
We have from respondent number 1 and 2.
Item number 10. State advocate is Mr. Wasim Ahmed.
He was not there, his name won't be recorded. Yes.
The respondent number 1 and 2, Miller.
In this matter,
Yes,
it has been called.
Yes, Miller. This is an application filed by the appellant, Miller. There is a can, Miller.
Use the microphone, Mr. You are Mr. Mondol.
Yes, Miller.
Name is same, but you yes. What about Bhattacharya? He's not there.
He's engaged.
Lordship, I appear online for the appellant's lordship.
Yes, you are for the appellant. Yes,
there
Mr.
was
Mondol.
a direction upon me for serving upon the respond number 3 to 5. Now service is complete, Lordship.
What is the affidavit of service?
Lordship, it will be filed by my clerk in due course of the Lordship allows me that.
Very well, that and you are appearing for those respondents, Mr. Mondol.
Yes, Miller. Only 1 and 2, Miller. Not those respondents. Only 1 and 2.
Lordship, upon service, what could I gather that respond number 3 had
Yes.
passed away on 13/11/2017.
Then you have to file an appropriate application for that.
Lordship, with by seeking liberty from Lordship.
Learned counsel for the appellants seeks liberty to file an appropriate application since respondent number 3 has met her demise in the meantime. Full stop. Such leave is granted. Full stop. Let the matter go out of the list for the present with liberty to the parties to mention the application for substitution, comma, as and when filed, comma, for inclusion in the list. Immediately after you file that application, mention all those together and we'll take up.
Lordship.
Thank you.
Lordship.
For the present out of it. Thank you. Order. Yes, next.
My lord, item number 12, I appear for the respondent number.
Yes, Mr. Sinha, how are you now?
Yes, I am better. I am doing regularly
Very
medicine
good.
virtual mode.
What is the application for?
And my lord, this is an application by the appellant for seeking extension of time after 6 years of an appeal arising out of order of injunction. That is their urgency. My lord, when in any event, if they are not present, that application needs to section 5 limitation will apply. They have not explained the delay. Father giving no objection to son is the ground.
No, a limitation for filing this extension of time application to file a paper book.
Paper book 6 years, after 6 years.
So, Sinha, that would be taking it too far.
My lord, in that
With
case,
pending appeal, no application is even required.
yes. My lord, only one.
You want to prepare paper books, we can direct you to.
No,
if
no,
you
no.
want.
My lord, the appeal is infractuous.
Why is the appeal? Why?
My lord,
Against an ad interim order?
no. Against an ad interim order was passed, against which a cross appeal. There are two suits. My lord, one by my client, other by their client.
Right.
City Civil Court. My lord, they obtain an ex parte order of injunction, ad interim injunction. My lord, against which I prefer an appeal. My lord, in my suit, I also obtain an order which is not ex parte, but that allows me to continue to run the school in Patna.
Right.
Yes, my lord, against both the ad interim, cross appeal was filed. Justice Division Bench of this Honorable Court, presided by Justice I.P. Mukherjee, as his lordship they know us in this court, my lord, decided that my client will continue to manage the affairs of the school and accepting the major expenses, accepting the salary and minor expenses, no major expenses will be incurred. My lord, and remanded the matter, sent the matter for final hearing of the injunction application. In final hearing of the injunction application, the learned trial court maintained the order passed by the division bench of this court. And that continued for 6 years.
Why do you say it has become infractuous? The suit is still pending. That is still continuing.
Suit continuing. Suit is still continuing.
We'll just adjourn it for the week, Mr. Sinha. Learned Senior Counsel appearing for you are for the plaintiff respondent, Mr. Sinha?
Yes, plaintiff respondent number 1 and 2.
1 and 2. Learned Senior Counsel appearing for the plaintiff's respondents 1 and 2 submits that the application ought to be treated to be time barred, since it has been filed 6 years after the time expired for preparation and filing of paper books. For next para, however, since the nature of the application is innocuous and the order sought in the application could, in any event, be obtained by verbal prayer for the purpose of adjudication of the appeal and is in aid of proper adjudication of the appeal, we deem the prayer made in the application to be one which is not squarely subject to Article 137 of the Schedule to the Limitation Act. Be that as it may, although none appears to move the application, in view of the innocuous nature of the prayer, we extend the time for filing paper books in connection with the appeal for a further period of 6 weeks from date. Next para, can 2 of 2025 is accordingly disposed of. Next para. However, it is made clear that in the event the paper books are not filed accordingly within 6 weeks from date, the matter be placed before us, the appropriate bench having determination under the heading Lawzima for final orders. Mr. Sinha, just inquire after 6 weeks if they have not filed the paper book. Gist of this order, a server copy of this order shall be communicated to the learned advocate appearing for the appellants by the learned advocate on record for the respondent numbers 1 and 2 at the earliest.
Only one addition.
Yes, Mr. Sinha.
If they file the paper book within 6 weeks, let the appeal be hard. It's a small hearing.
Let them file first.
Yes.
If they don't file first,
liberty to mention.
Liberty is always there, and you will mention it definitely. You just communicate this order, ask your learned junior to communicate this order to them. If they don't comply, then we have directed it to appear as lodging of final orders. You just point out to us that this is the scenario, we'll put it as final order.
My lord, my lord.
Thank you, Mr.
True Navavarsh to both the
So
my
now
lord.
to you too, from both of us. Yes.
And if your lordship was when in our side, my lord,
Yes.
we used to discuss 13, 16, and 19 are lucky codes. So
Lucky
I
number.
yeah,
Lucky code, such a 13 is
lucky
my
code,
lucky number, 16 is not.
yeah, lucky code for the judges.
But I have a caveat there. I'm still on your side, all of your side.
My lord.
Yes. What is the next matter? Mr. Rai, yes. Let us try to prove it that we are on your side. What is the matter?
This suit for partition, my lord. Plaintiff is the petition before your lordship. Suit dismissed on the ground of non-inclusion of the necessary parties. Challenging that, my lord, I am before your lordship, where it is held that he has plaintiff has shared in suit
No, this application is for
injunction.
injunction.
Lord, I have filed my
Supposition, yes, you have filed.
Uh,
No, the suit was partition suit was dismissed for non-joinder. Yes, injunction you are enjoying an ad interim from us.
Yes.
What is the premise of this? Let us hear you first.
My lord, only 3 submissions to make. My lord, one, my lord would kindly take their injunction application at page 6. My lord, we are also in possession of the suit property. Number 2, my lord, this appeal was filed in the year 2000.
They have sought for an injunction restraining from disturbing their position.
Disturbing their
So you say you are also in possession.
I'm in
All
possession.
right. We granted status quo must have.
Number 2, my lord, this appeal was filed in the year 2019.
Right.
My lord, admittedly, there was an order of injunction prevailing before the learned trial court. My lord, since 2019, my lord, they were unprotected. My lord, there was no order of injunction. My lord, there is no, but they have not made any disclosure as to why, as to now they seek an order of injunction as on this day.
Even after filing of this appeal, there was no injunction. No. Ah.
Since 2019 till 2025, there was no.
Let us find out something from the application.
After passing of the degree, it was 2019 it was filed. After that COVID, this application was filed along with the memo of appeal. It is not that it was subsequent.
Now trying to interfere.
And now after passing of the degree.
What is the third?
And third submission, my lord, since I am in possession, my lord.
Yes.
That is the
undue hardship will.
You are in exclusive possession, you were saying.
They say that they are in possession. We are also in
So we'll dispose of the application by taking this on record and granting status quo as regards possession. Definitely, we have to, Mr. Wali. The present application for injunction has been filed in connection with an appeal which has been preferred against the dismissal of the appellant's partition suit primarily on the ground of non-joinder of necessary parties. Full stop, next para. We are satisfied as to a prima facie case having been made out, comma, insofar as the well-settled legal principle is that an opportunity ought to be given to the plaintiffs to add the omitted parties in the event the trial court is of the opinion that a suit is bad for non-joiner of necessary parties. So, Mr. Banerjee, if you agree, we can dispose of the appeal and remand it.
Appeal?
We'll direct remand it and direct them to add the non-joined parties and
because certain names are appearing in the record of rights. The court
Because
of the
settled-
opinion, they should be made party, whether they have any interest.
We are disposing of the injunction today, but if you are agreeable to that, you can mention on immediate and we'll just pass an agreed order.
My lord, may I take instruction, my lord, since the
Take instruction. Let us dispose of the next para. Learned counsel appearing for the contesting respondent numbers 1, 2, 4, 5 and 3 within bracket small I submits that the said respondents are also in possession of the suit property and as such no order of injunction can be passed to protect the alleged exclusive possession of the appellants. Full stop, next para. Secondly, comma, it is contended that there is no explanation in the injunction application as to the huge delay in filing the same after preferring the appeal itself. For some next para, we find from the application that the same was filed simultaneously with the appeal. For some moreover, comma, the cause of action regarding alleged disturbance of the possession of the plaintiff stroke appellants is a continuing cause of action and as such, comma, on the face of the averments made in the injunction application, comma, we do not find any undue delay in preferring the same. Full stop, insofar as the position of the parties is concerned, comma, since the appeal arises from a suit for partition filed by the plaintiffs stroke appellants themselves, comma, it is an admitted position that both parties are in possession of the property. Full stop. Accordingly, we are of the opinion that during pendency of the appeal, comma, none of the parties should be permitted to disturb each other's physical possession, comma, as it is today, comma, in respect of the suit property. So accordingly, can 1 of 2019, bracket, old can 9962 of 2019, bracket closed, is disposed of by granting status quo, by directing both parties to maintain, by directing all the parties to maintain status quo with regard to the possession in respect of the suit property till disposal of the appeal. Full stop. The in view of the appearance of respondent numbers 3 within bracket small I, comma, in view of appearance of respondent numbers 1, comma 2, comma 3 bracket small I, comma 4, comma 5, 4 and 5 through their learned advocate in court today in connection with the appeal, comma, service on the said respondents, service of notice of appeal on the said respondents is dispensed with. Full stop. The appellants shall put in requisites for service of notice on the other respondents within a week from date. Full stop. The appellant shall, the trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. Full stop. Next para. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention for inclusion of the appeal in the list as and when the same is ready for hearing. Full stop. Next para. It is made clear that since the conspectus of the appeal is brief, comma, as indicated above, comma, since the infirmity in the impugned judgment is only as regards not giving an opportunity to the appellants stroke plaintiffs to add the omitted parties and does not apparently touch the merits of the contentions of the parties, comma, it will be open to the parties to amicably resolve the appeal and mention the matter before court for passing orders appropriately in the meantime. We have made it clear in an order so that it helps you with your client. Prathame affidavit in opposition file to be kept on record. Thank you. Thank you. Respondent.
Yes, Lordship, Mr. Boidujo Ghoshal appearing in the court number 33. Lordship, kindly give short pass over.
I am appearing on behalf of the plaintiff appellant, my lord. There are two applications which just filed. I have served the copy on.
Mr. Ghoshal was present on all the last occasions, but you are not, so 50-50.
Yes. No,
now, therefore, we are making it not today. We can't wait.
Monday, my lord, because
Monday, very well. Because what? Tomorrow something? Because?
Tomorrow, my lord, Haibaru Oman, who is the my lord advocate on record, he is ill.
Oh, great. And a passover is sought on behalf of the respondent numbers 8, 9 small a. For some of the learned advocate for some of the respondents. Push up. Accordingly, let the matter stand adjourned and be listed next on April 21, 2025, Monday.
Sure, no,
Same to you. Only after getting the order, you are saying, we remember.
No.
Yes, next. None appears for the parties, adjourn for the day. Next.
This is my application, this is my affidavit of service.
All served?
But this is a matrimonial appeal.
My lord, learned senior advocate appearing for the appellant.
Who is the senior advocate appearing for the appellant?
Learned Pradeep Chatterjee.
You are for the respondent?
Petitioner.
You are also for the appellant?
I am for the appellant.
No, my lord. Apni to respondent. Apni ki kore appellant hobe.
Let there be a duel.
Yeah, so far, so instruction given to me.
Sir, this is a matrimonial.
The instruction is obviously wrong.
He has
Mr. Pradeep Bhattacharya is appearing for the respondent in this matter. Do you know that?
I don't know, my lord. I have served him. He, my lord, intimated. He is for, perhaps he is for the husband, my lord. This is a matrimonial appeal. My lord, suit for dissolution of marriage, my lord.
This is a condonation application.
Yes, my lord.
Yes, where is he, Mr. Bhattacharya?
Actually, he has gone to Murshidabad to see his ailing father. He has got stuck there due to some disturbance.
You are there. You are the advocate. Who is the advocate?
No, I am not on record. I am
The
his
problem
friend
is
and he
that
has asked
19
me
is a
to
date
move
fixed by the
before the
London
order.
Code below for domestic violence, my lord. And there
What
is
does this have to do with domestic violence?
My
You
lord,
you have challenged what, a divorce decree?
yes, my lord.
So
Because
what does the domestic violence have?
because London Code below unless we have got the order for stay. My lord,
Stay of divorce decree does not help you in domestic
yes, my
violence.
lord, I know that, but the learned
No, that
advocate
has nothing to do.
pursuing the matter insisted.
Is there a stay order or stay application also?
Yes, my lord.
You are you have remarried in the meantime.
I have no instruction in this matter. Can you please make it on tomorrow?
Tomorrow I have some difficulty. That's why.
We'll keep it on Monday then. Monday. An adjournment is sought on behalf of the respondent. Let the matter stand over till Monday, till April 21, 2025. The affidavit of service filed today be kept on record. Huh?
Defect. What is the defect?
Subject to my lord kind consideration.
Acha, the learned advocate on record is granted leave to amend the memorandum of appeal in the meantime to rectify the defect pointed out by the department. Memorandum of appeal from original decree. You have written judgment. Do that right now. Uni correct kore den memorandum. Thank you. The other defect than time, but Mr. Rai, not checked up.
No, so but the other appeal is concerned.
No, any other defect. The one is out of time.
Only out of time, subject to question.
What about this substitution application? Recording date.
Recording those are allowed. But if you logically takes up the order dated 24th March 2020.
What is pending now?
Now section 5. The two appeals counterclaim in a partition suit has been filed. Suit was decreed in part.
You have challenged one part, they have challenged.
No, initially filed an appeal challenging the original degree, allowing part of the appeal, part of the suit. There only one appeal was filed.
The part of the suit means it was a preliminary decree.
Preliminary degree allowed in part by directing that exclusive right identity is A schedule property and joint in a B schedule property. My claim is that both A and B schedule both are joint property.
So you did not prefer an appeal then?
At that point, I did not prefer an appeal. This is
final degree passed.
No, preliminary degree passed. I preferred an appeal, allowing the A schedule property to be the exclusive property of the plaintiff.
Why section 5?
Yes. No. Now, so far my counterclaim for declaration of the A and B and for partition that was turned down.
Achha.
Challenging that, only the one appeal has been filed.
What is the delay?
Delay is regarding the filing of the.
What is the
66 days delay.
You have given a copy to the other side.
Yes, my lord was pleased to direct us to.
Whether you have complied with the direction, that is the question.
Yes. Well, today, my lord, I don't want to.
No, have you served? Where is your affidavit? Affidavit of service, yes. I mean, it was filed on the last one.
My lord was.
No, you can move the application because on the last occasion we had recorded that affidavit of service filed, supplementary also filed.
Yes.
You have served a supplementary affidavit copy also.
Also, that is
none appears for the respondents.
That's why your lordship was pleased to adjust the matter
Now,
of that.
also they're not appearing, we'll take up the matter. Why is the supplementary affidavit? Explanation there.
Explanation of the delay.
66 days.
66 days delay because initially, my lord, we had not been advised to file two appeals. Accordingly, my lord.
They did not take any step to remove this defect.
Certified copy of the impugn decree do not file presently posted. Some of the parties have not been implicated in the.
Yes. Sukumar. Their name is.
What about that?
Sukumar Mitro and Anima Saha did not get name in the list of the appellants. The name of.
Well,
you check up your.
May I go through the.
You check up your memorandum.
Yes, ma'am.
Sukumar আর কি অনিমা তারা কত Sukumar Mitra 6A and Onima 6E in the trial court's degree. Are the parties to your memorandum? Sukumar Mitra and Onima. They are the heirs of Mongola Mitra. They should be with Karthik, Pratima and Mamoni. Not there.
Then I have to. Karthik Mitra meant party. He cannot be. Pratima is there.
Karthik Pratima Mamoni must be there.
Yes, they are 9, 10, 11 are there.
Sukumar and Anima are not there. ওই দুজনই নেই শুধু। Since their other co-heirs are already on record, we are not holding that the appeal is time, but against them, do the corrections today.
I leave them granted. I beg to.
This is the second consecutive occasion when none appears for the respondents despite service. Full stop. The present application is for condonation of delay in preferring the appeal. Full stop. Next para. We learned counsel for the appellant submits that initially an appeal had been filed against the partial refusal of a decree in terms of the prayers made in the plaint by the appellants in the court below. Full stop. However, comma, although the previous appeal was preferred against such preliminary decree in a partition suit, comma, the appellants had omitted to challenge the other part of the decree whereby the counterclaim seeking declaration of title of the appellants in respect of a portion of the property was also turned down. Full stop. The explanation given in the application for condonation of delay, comma, read with the supplemented affidavit to the extent that the appellants, comma, being laymen, comma, were somewhat ill-advised stroke. There was a communication gap, comma, regarding the necessity to file a second within bracket a second the double inverted second কথাটা a second first appeal against the dismissal of the counterclaim, comma, the appeal could not be filed earlier. Full stop. Considering the span of delay, which is of about 66 days, and the sufficiency of the reasons, comma, can 1 of 2023 is allowed, comma, thereby condoning the delay in preferring FAT 432 of 2023, full stop, the appeal be deemed to stand admitted and registered. Registered and admitted. Full stop. Next para, the learned advocate on record for the appellants is granted leave to carry out the necessary amendments to the cause title of the memorandum of appeal by implementing the names of the omitted parties, comma, whose names appear in the trial court's decree, comma, during the course of the day.
One thing, my lord, there's the indication in the computer section that can 3 of 2023 is still pending, but it has already been disposed of by order dated 24th March 2025. Subject to correction, my lord, it is. But the computer মধ্যে দেখা যাচ্ছে সেই জন্য আমি করি oh
computer section still is showing that
pending, that is
actually say তাহলে computer ওটা
get filter.
What is can 2?
Can 2 is for injunction.
You are not pressing that you are recording.
No, in view of the order passed in the earlier.
We have already passed. So any other order required?
Yes, well, both the appeals we had analogously. May I supply the number of the other appeal which is pending?
We have passed paper book directions in the other.
No. So if your lordship is kind enough to,
we'll just record that this will be heard along
with that. So I can take the steps.
What is the number?
Yes, my lord. Number FAT number
FAT 432 of 2023.
Yes, my lord.
Shall be heard analogously with. It should be there in the section 5 application. That is your explanation, in fact. Along with
378 of 2024.
Be sure.
Yes.
FAT
378.
FAT or FA?
FAT. My lord, I
write it on a slip of paper so that we can catch you later if you make a mistake. Write it on a slip of paper. যেটা পেপারে লিখে দেবেন সেটাই লিখবেন এবং ওই পেপারটা রেখে দেবেন এটার সঙ্গে। পার্থকে পরে ধরবো। Yes. You write it in your handwriting, not with genius.
In my handwriting, taking entire responsibility on my shoulder.
So we can catch you at the time of correction when you see correction to mention and all this. But do it right now, Mr. Rak. 18. Appellant.
Appellant was the appellant led by Mr. Bolton.
Apart from adjournment, whatever.
Only adjournment.
No. What is the matter about?
Client could not come to affirm.
So what you have come? To affirm what?
There was a direction to file a supplementary affidavit. The client
Oh.
would not come to affirm the same.
Your client is also from Murshidabad. Everybody who is not affirming affidavits are coming from either Murshidabad or Malda.
From North Bengal.
Thank God.
You kindly grants me 4 weeks adjournment.
4 weeks for supplemented affidavit. Very sorry. Howrah. 4 weeks.
My lord, he is working for gain in North Bengal, my lord.
North Bengal one night.
Could not come, my lord. He's not getting holiday.
Why 4 weeks? What does he do?
He's the bank manager, my lord.
Not 4 weeks. 4 weeks is too much. He may be a bank manager. But
3 weeks, my lord.
no.
Kindly, my lord.
Bargain a little bit more. We'll make it fortnight. An adjournment is sought. An extension is sought by the appellant to file supplementary affidavit in connection with the injunction application. Full stop. Accordingly, the time for filing supplementary affidavit is extended for a fortnight from date. The matter be listed next on May 6, 2025 under the same heading. Yes.
I'm with 20 years to know 1 month.
Yes. What about the others, Mr. Datta?
The others one
Service?
had recorded in the
Oh,
last
recorded.
one. No, it was served, but
avoiding and all this.
yes, the names were the
Well,
addresses were supplied by my learned senior friend.
Yes, he did.
My short point.
Oh, because he was not there. Mr. Nundi was not there on the last.
On the early office.
What is the matter about?
A very short point in the appeal. My lord, preliminary decree passed only without considering that my LA case is pending.
Your LA case is pending. So what?
My lord, LA case is pertaining to a will of the same property. My lord, where the partition, if my lord,
letters of administration case.
Yes.
Please
My lord.
tell the full thing.
My lord.
LA case may also mean land acquisition. Yes, we generally mean land acquisition. LA case is pending.
I'm extremely sorry.
Not expected,
Yes,
Mr.
my lord.
Your letters of administration proceedings pending regarding.
Only this has not been considered, though even the
Pendency of letters of administration case. How can that be a ground?
The entire scenario would change. My
Mr. Dattu, you could have applied for under section 10 of the civil
I could
procedure.
have, but
There is no fault in the order.
the
We'll dismiss the appeal right now then. Why
the
shouldn't
entire scenario would change. My lord.
Would change?
We both would be having 50% shares each if
that is allowed.
If that is allowed. Now it is 1/3.
Yes, but pendency of that ipso facto that was pointed out to the trial.
Yes, pointed out, but the learned trial court points out that
Trial court deals with that in the judgment.
Deals with, but says that no substantial evidence have been placed before this court. So
that is a good ground because we have checked up. Section 10 need not does not require an application. Also. If that was considered by the trial court.
Yes, it was considered, but
what is the stage now in that?
Service.
In the letters, rightly so. Why should you grant a stay?
Only because apart from my learned senior friends' clients, none are apparently interested in the property. They are avoiding services.
They are the plaintiff. They have to be interested.
There are several parties who are.
My instruction, the LA case was filed. Probate application was filed earlier. It was rejected.
Well, at his instance.
Then we have to hear it. Yeah. But then we have to grant stay because this is an arguable point. The present appeal arises out of preliminary decree. Out of a preliminary decree of partition passed in the suit for partition filed by the present respondent number 1. Full stop. It is contended on behalf of the appellant that the learned trial judge failed to take into consideration the legal effect of section 10 of the Code of Civil Procedure insofar as different proceeding for grant of letters of administration with regard to a will, comma, the outcome of which might alter the shares of the parties, comma, was pending at the juncture when the impugned judgment was passed and till date. To sub next para, since the appeal is required to be heard on such issue, comma, on such question and the other grounds taken in the memorandum, comma, we find that prima facie case for hearing the appeal on merits has been made out. Accordingly, can 1 of 2024 is allowed on contest, is allowed, comma, thereby granting stay of all for, no, not stay, then, thereby directing the learned trial judge to continue with the final degree proceedings, semicolon, however, comma, the learned trial judge shall not draw up a final decree without prior leave of this court till disposal of the appeal. Full stop, the appellant shall put in due requisites for service of notice of the appeal on respondent numbers. Did they appear in the court below?
No, they have not appeared more. They are not.
আচ্ছা, very well. তাহলে ছেড়ে দিন এটা যে লাস্ট সেন্টেন্সে কেটে দিয়ে in view of appearance of the plaintiff stroke respondent number 1 through her learned advocate, comma, service of notice of appeal on the said respondent is dispensed with, full stop. Service of notice of the appeal on the respondent numbers 2 to 10 is also dispensed with, since the said respondents, comma, being defendants in the partition suit, comma, did not contest in the court below. Full stop. Accordingly, the appeal be otherwise treated as ready, treated to be ready as regards service. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, which shall be deposited within a week from date. Full stop. However, comma, the learned trial judge shall retain a skeletal records for the purpose of proceeding with the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Application disposed of.
Pardon?
Application disposed of.
Yes, yes.
Yes, we have started with that.
Can
Dispose of, can such and such dispose of.
Already.
Yes.
20 minutes in this matter, I am appearing for the appellant. The wife is the appellant. One thing I draw your lordship kindly takes up 74.
Appearing for the first time.
No, this direction was there, my lord.
Service.
Good service.
Not checked up. Yes. No, she has checked up. Could have.
Received.
We have checked up. Yes.
Sorry, my
Yes.
lord. Section 24 for declaration that marriage is void under the Special Marriage Act. Because at the relevant point of time,
That has been decreed.
refused to pass a degree.
You filed that suit.
Yes.
That the marriage is
Without
void.
that marriage is void because at the relevant point of time, the husband has a subsisting marriage at that point of time when he contracted the marriage.
Yes.
My I draw your 74, page 74 of the order input. I don't know what the learned trial court or the court below wants to spell out.
Yes.
Top from the second line from the top. This court finds, man, I got it.
Page 74.
Page 70, the order, the application. My lord is kindly considered 74 of the application.
Yes, application can 2.
Yes.
Can 2, yes.
74, the last page of the order.
Last page of the order, yes.
Second line from the top.
Acha, this code. After the comma, you started from the middle of.
Yes, yes, this court.
This court finds.
Finds that the respondent husband filed an application under section 13(1)(b) of the Hindu Marriage Act against Sitama Bhaduri, who is the earlier wife, claiming himself as husband of Srimati Bhaduri and seeking divorce against her by dissolving the marital tie between them. The plaint was filed on 17/12/2019. As per exhibit P8, PW2 11/3/2000, it is the date fixed for expert hearing, which means the suit is yet to be decided. In the circumstances, there is no issue before this court to hold that the present respondent is a married person and Sitama Bhaduri is the name of the existing wife at the time of marriage of him with the present petition.
That suit is not for a suit for nullity.
No, the divorce, I annexed the plaint. So at that, the consideration is whether at the time of effective marriage, whether any spouse is alive or not. After holding that,
1 minute appeal.
yes, that is why paper books are already been filed. They are not appearing from.
Paper books have been filed in
Yes,
this matter.
yes.
We'll take up the appeal tomorrow for him. It is submitted by learned counsel for the appellant that the paper books have already been filed in the matter. Notice has been served of the appeal on the other. That we don't know.
Notice have been service হয়ে গেছে?
No, service of notice of the appeal. Check up, we are holding our order.
না না দেখি সার্ভিসটা এফেক্ট হয়েছে।
No, check up. দিন আপনি দাঁড়িয়ে গেলেন কেন? ওনাকে দিন।
ডোর ক্লোজ বলে
দেখিনি বাবা মিস কেসেস হয়েছে এদিকে যাইনি
রিপোর্ট নেই, there is no report, Mr. Rai.
এলসিআর ফাইলস বা ডোর ক্লোজ মানে এর মধ্যে কিছু আছে কি অর্ডার শিটের মধ্যে প্রথম দিকে কিছু আছে কি অর্ডার
শিটে প্রথমে থাকে
অর্ডার শিটের মধ্যে ফিলোসফি এখানে এলসিআরটা এসছে নেই
অর্ডার শিটে
পেপার বুক আমি সব ইয়ে করে দিচ্ছি এখানে দিয়ে দিচ্ছি আরো সেট পেপার বুক আছে 2 সেট পেপার বুক দিয়ে দাও এখানে তাহলে আর আনার দরকার পড়বে না
Tolobana not put in.
তলবানা কই ইয়ে পার্টিকুলার কই
Let us see whether there is something subsequently. Yes, subsequently no, has not been put in. On 11th of June 2024, there was a recording by the Registrar Administration LNOM that although that was the report of the office, Ms. Basu Thakur had submitted that you had deposited Tolobana. So a further report was sought. Where is the further report? No, you have files. She has deposited subsequently.
And the expertise degree, the procedures is also expertise with the landed code bill also. Mylan can consider the can 1 also for the purpose of.
Yes, we'll decide. Give us half a minute.
Can 1 টা কি আছে?
এটা যদি অ্যালাউ করি আমরা তো রিমান্ড করে দেবো, ট্রায়াল কোর্টে মেরিটে শুনতে বলবো।
দরকার নেই আমি এখান থেকে পেপার দিয়ে দিচ্ছি
এটা যে অ্যাডমিশন রয়েছে তাতে তো এখান থেকে ডিগ্রি করে দেবো।
This is the admitted fact on the basis of the documentary evidence that she was
right here. Degree your suit from here.
Once, my lord, if your lordship remanded the matter subject to there, my lord,
but certain other things have to be proved. Even if they have admitted,
it is their plaint.
The dates have to be seen.
Yes, it was pending.
It was subsisting at the time.
Subsisting, my lord.
Even at the date of
the marriage, I have to prove that.
In the date on the date of the impugned judgment.
Judgment also.
No, yes.
Yes, to the fact whether on the date of the marriage or not.
No. The date of the marriage we have to see. That plaint is also annexed.
Yes.
That says that marriage was contracted before your marriage.
Before my marriage.
Your marriage certificate has been annexed.
Yes. Everything is there.
We have to look at. Give another notice of the appeal. We'll treat that to be a notice of the appeal. But notice of appeal has been served. You have put in Tolobana. No, there is no note that it has been served.
No.
You can try to find out from here, Mr. Rai. We want to dispose of this appeal. These appeals are unnecessarily, kept pending. The lives of several people are. Yes, if you can, we'll decide it.
Instead of having knowledge, I have contracted the marriage.
Now they have admitted. If it's an admitted position, then why shouldn't it be granted it? We'll take the dates and just. ডিপার্টমেন্টের দোষ আছে সেটা একটু মানে হয় প্রথমে ভুল রিপোর্ট দিয়েছিল তারপরে বলার পরে ওরা তারপর ঠিক হয়েছে লোকের লাইফ ওয়েস্টেড হয়ে
After that, there is no indication whether they are busy. No. It appears from the order dated 3rd July 2024 that notice of appeal has been issued upon the sole respondent through ordinary way of service by memo number such and such.
They had not appeared in the court below.
No.
আচ্ছা ট্রায়াল কোর্টে appear করে আমরা নোটিশ ডিসপেন্সিটি করতে পারি প্লাস আমরা এর সঙ্গে যদি রেকর্ড করি এটা যে
Details, yeah.
এটাতেও ডেলিভারেটলি অ্যাভয়েড করছে অ্যাপিলটা কালকে ফিক্স করি
না, ঠিক আছে, ডিপোজিট করার মনে করছে, ঠিক আছে।
Technically, we cannot dispose of the appeal today because we'll
yes.
keep it the appeal for hearing tomorrow along with the application so that it appears. No, record.
Notice of sole respondent are already issued.
Postal cost দিয়েছে
It has already been deposited.
লেফট বলে অফিসে এগুলো রিপোর্ট দেয় না কেন আশ্চর্য লেফট বলে হ্যাঁ যে অ্যাড্রেসে
Yes,
she's right actually. Our office is lax in this.
Because deposit had not been taken into account.
Right, absolutely right.
Fine.
Ms. Basutakuri is absolutely right. The door locked and all, everything. Not only locked, but locked from outside. Mr. Rai, we are fixing it tomorrow for hearing of the appeal.
Yes,
At
yes,
order.
My lord, I beg your pardon.
You are also in this matter, my lord. Learned, the present application is for appropriate orders, seeking expeditious disposal of the appeal. Full stop. Next para. An extremely brief question is involved in the appeal. Full stop. The learned trial judge has dismissed the appellant stroke wife apostrophe suit for declaration that the marriage between the appellant and the respondent is a nullity in view of a subsisting prior marriage of the respondent husband at the time of the marriage between the present parties. Full stop. Next para. It appears from the impugned judgment that despite having recorded that a previous suit by the respondent husband for divorce against his previous wife was pending at that juncture, the learned trial judge refused to decree the present suit. Full stop. The very fact of pendency of a divorce suit at the behest of the respondent against a different person whom the respondent himself admits in such plaint to have married prior to the present appellant shows that there was a subsisting marriage at the time of the marriage between the present parties being contracted, which furnishes sufficient ground for granting a decree of nullity in respect of the marriage between the parties. Full stop. Next para. We find from the affidavit of service filed today that despite service, none appears for the respondent. Full stop. But this service was effected properly. This application. We also find from the track report that due service was effected on the respondent in respect of the application at the very address which is mentioned in the memorandum and the cause title of the application. Full stop. After going through the records of the case, we find that several previous attempts to effect service of notice of the appeal on the respondent met with failure since the envelopes returned with the endorsements door locked, left, etc. Full stop. It is noticeable that the respondent husband also did not contest the suit in the court below, despite service of summons. Full stop. Next para. Taken as a whole, it is clear that although the husband was duly served at the very same address in respect of the application, the husband is avoiding service of notice of the appeal deliberately. Full stop. Accordingly, we deem that proper service of notice of the appeal has been effected on the respondent husband. You have prepared your paper books.
I have already filed, but for the
copy, the appellant has already filed copies of the paper books in connection with the appeal. Full stop. Since the appeal is otherwise ready for hearing, we direct the same to appear along with one of whatever the application number.
Two of 2024.
Sorry, can 2 of 2025 under the same heading tomorrow. Full stop. Let it be understood that the appeal shall be taken up for disposal along with the application when the matter is next called on for hearing. Thank you.
My lord,
Yes. But refusal is the good service. এটা application respect আগে
I made an unintentional mistake.
What is the mistake?
In
which item?
Item number 16, I appeared instead of 26, I appeared in 16 due to wrong instruction by
16. What order did we pass?
My lord, order has been passed. My lord, on behalf of they are taking adjournment. My lord, please to fix this matter on 21st. 19 is a date fix, my lord. That's why. Tomorrow I have some difficulty. That's why my lord fix it on 21st.
Let that order be there. What can
Because they are Lord Pradeep Chatterjee's name has been recorded because he's not
in this,
in that
he's in
that matter.
26.
He is
Item
wrongly appeared in this matter.
ওটা কি তুমি নিয়েছো 16টা আগে যে ছিল 16টা থেকে রেকর্ড করতে বারণ করো উইল টেক আপ 16 আফটার উই কাম ব্যাক আফটার 12 16টা What is the matter?
What matter is relating to the.
Still you are.
No, I mistakenly appeared in item number.
That's why you are calling it. Now you take your seat. You are not in this matter.
But
Tension free now. Yes.
Matrimonial matter, dissolution of marriage has been filed before the learned court by the opposite party, and that was allowed. Challenging that, I came before your lordship.
So what is the scope of an interim order? Divorce has been granted.
Yes, my lord. Interim order, my lord, I am praying before my lord.
Or the divorce has been granted in their favor.
Yeah.
Dissolution
Yes,
has been
yes,
granted.
yes, my lord.
Remarrying then.
In the meantime, 145 days delay, my lord.
145 days. Why?
Because my lord, I was ill. That's why, my lord, there is a little bit delay to file.
Have you served copy of this?
Yes, my lord. I have filed my affidavit of service.
Good service.
Yes, my lord. Kindly, my lord.
You have filed affidavit of service regarding only the section 5 or the.
No, as well as stay.
Very well. Affidavit of service filed today be kept on record. Despite service, none appears for the respondent. First up, the present appeal arises out of a divorce decree obtained by the respondent. First up, we find from the averments made in the application for condonation of delay that where have you stated medical papers? Yes, that due to the illness of the applicant, comma, the appeal could not be filed within time. Full stop, next para. Accordingly, comma, since sufficient reasons have been furnished for the delay, comma, can 2 of 2025 is allowed, comma, thereby condoning the delay and preferring FAT 430 of 2023. Full stop, the appeal is accordingly deemed to stand registered and admitted. Sub can 1 of 2024 is also taken up for hearing, is now taken up for hearing. Full stop. Since the appeal has been preferred against a divorce decree, comma, although couched in the manner of an application for stay, comma, we mold the relief sought in the present application and are of the opinion that unless the respondent husband is injuncted by an order of injunction from remarrying in the meantime, comma, the appeal will be rendered infructuous. Accordingly, GAN 1 of 2024 is allowed, comma, thereby restraining the respondent husband from contracting a remarriage, contracting any remarriage during pendency of the appeal. Next para, the appellant shall put in due requisites for service of notice of appeal on the respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, comma, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Obliged to
Thank you. Yeah, please come back once. Key correction. তাহলে এতে হ্যাঁ একটা লাইন অ্যাড করে দিন লিবার্টি শুড
I corrected that, my lord.
that order is no longer there. Liberty is given to the learned advocate on record for the appellant to carry out the necessary correction to the memorandum of appeal to rectify the rectify the defect as pointed out by the department. Thank you. Yes.
May I beg to appear on behalf of the appellant, madam? Can 4 of 2025 is my.
Sir, Vishwas was appearing. You are appearing for the other side.
Appearing for the respondent number
1 and 2.
21.
Pardon? For?
Respondent 20 number 1.
On the last occasion, you appeared for 1 and 2.
Only one, one.
But I am.
But I did not obtain the power. Only I obtained the power of in respect of.
You have served on all.
I've served on all. Can 1, 2, and 3 I've served on all. Can 4 is my application for.
1, 2, and 3 have been disposed of.
They have to be heard, madam. Directions were there to serve on the other side. We have served, madam.
You have served on all the 2 respondents only. They were the plaintiffs in the court.
My lord,
The direction was to serve on only 1 and 2.
my lord, my lord.
What is the suit for?
Partition.
What is can 1? Delay.
Can 1 is delay, but can 4 is my leave to prefer an appeal. One of the, in fact, the plaintiff number 1 had died. In the meantime, my lord, I'm sorry, the defendant number 1 had died, but he was not substituted by his legal heirs before the learned court below. His legal heirs have come up before this honorable court by way of this appeal.
1 second. The person died during pendency before passing of the preliminary degree.
My lord,
Before.
my lord.
Then if you did not prefer an appeal application in the court below in the suit, how can we do that?
But I was a defendant. I was not the plaintiff.
Oh, right. Very well. So who are those heirs?
But my will kindly come.
You are for which of the defendants?
But all the defendant numbers 1, 2, 3, 6, 7, 8.
Only 5 is omitted.
Only 5 is omitted. 5 I am not representing.
5 heirs were are to be the leave is for
leave is for substitution of the defendant number 1's heirs. And regarding the defendant number 5 has also died, but I am not representing him.
But his heirs, what about
his heirs have added them as pro forma respondents. I have sought for leave for that as well.
You are granting that leave because you are a defendant. He could not. Can 4 of 2025 is an application captioned to be one for appropriate orders, comma, but in effect an appeal, an application for leave to prefer the appeal. Full stop. It is submitted by learned counsel for the appellants, comma, who are defendants in the court below, comma, that the defendant number 1 in the suit, comma, defendant number 1 in the suit for partition, comma, against a preliminary decree passed in which the present appeal has been preferred, comma, died during pendency of the suit prior to preferring the appeal. Full stop. Next para. Since the heirs of the said deceased were not substituted by the plaintiff's respondents in the court below, comma, the present application has been taken out for leave being granted to the heirs of the deceased defendant number 1 to prefer the appeal. Furthermore, comma, the defendant number 5 in the suit also died during pendency of the suit, but was not substituted in the trial court, comma, for which leave has also been sought for preferring the appeal against the heirs of the said deceased defendant number 5, comma, being pro forma respondent numbers 3 to 6 herein. Full stop. Next para. In view of the facts and circumstances as narrated above, comma, can 4 of 2025 is allowed, comma, thereby granting leave to the appellants to prefer leave to the appellants, comma, including the heirs of the deceased defendant number 1 in the suit to prefer the appeal. Full stop. Leave is also granted to prefer the appeal against the pro forma respondent numbers 3 to 6, that is the heirs and legal representatives of the deceased defendant number 5 in the suit. No orders to cost. Yes, what are the other applications for?
Can 1 is 1 and can 2 is our applications for section 5 and stay respectively, my lord.
What is the delay 208? What is the reason for the delay?
The only thing I must point out before I proceed with this application, there is a error in respect of the cost title. It is written as the court is described as Learned Civil Court Senior Division at Katua, Purvo Medinipur. It should have been Purvo Bardhaman. It could not have been Purvo Medinipur, and the same thing has been stated in paragraph 1 of the application as well as the prayer of the application.
Prayer and cost title we can direct you to correct.
Section 5 and
the memorandum also same thing.
Memorandum is memorandum. Nothing has to be changed. Memorandum.
The preamble of the memo. Just check up.
And memorandum. It is written Purva Bardhaman.
Very well. We are granting you leave to in all the applications.
Can 1 and can 2, my.
Leave is granted to the learned advocate on record for the appellants to carry out the necessary corrections to the cause title and the prayer portion of Can 1 of 2024 and Can 2 of 2024, insofar as the district should be mentioned as Purbo Bardhaman instead of Purbo Medinipur. Such corrections shall be carried out during the course of the day. What is the reason for the delay?
Firstly, one of the appellants had died. The original appellant had died, and secondly, my lord, he was keeping in touch with the clerk of the learned advocate, not directly with the learned advocate, and there was some miscommunication. The
What do you
learned
say
clerk-
to the section 5?
But I have nothing to say.
Thank you. Fair enough. Upon hearing learned counsel for the parties, we find sufficient reason for the delay in preferring the appeal having been made out. So accordingly, Can 1 of 2024 is allowed, thereby condoning the delay in preferring FAT 114 of 2024. The said first appeal be deemed to stand registered and admitted. Stay application. This is against preliminary degree.
My lord.
Will dispose of the application, will direct the learned trial judge to continue with the final degree proceedings, but final usual order. Final degree won't be drawn up without leave of court. Very well. Can 2 of 2024 has been filed for stay of all further proceedings of the suit. The present appeal arises out of the preliminary degree passed in a partition suit. Upon hearing learned counsel for the parties, Can 2 of 2024 is disposed of by directing the learned trial judge to continue with the final degree proceedings. However, no final degree shall be drawn up without prior leave of this court till disposal of the appeal. No arrest to cost. Can 3 of 2025 is an application for production of additional evidence. By its very nature, the said application ought to be heard along with the hearing of the appeal. The respondents are directed to file their affidavits in opposition, if any, to the said application within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. Can 3 of 2025 shall be heard along with the main appeal. Next para, in view of the appearance of the plaintiff stroke respondent number 1 through his learned advocate, service of notice of the appeal on the said respondent number 1 is dispensed with. The appellant shall deposit due requisites and costs for service of notice of appeal on respondent number 2 as well as the pro forma respondent numbers 3 to 6, because it's a partition. 3 to 6 within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The learned trial judge, however, shall retain skeletal records for the purpose of continuing with the final degree proceedings. Next para, the appellant shall prepare and file the requisite appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. If you can, in the meantime, if you can get the vokalatam of the other one, you can file it. So that will take care, that will expedite the appeal. If you do that, write a notice to them so that they don't put in the postal records. Yes.
And for the appellant, in this matter, what
Yes.
happened before the before passing of the preliminary decree, one of the defendant died, and the court passed a preliminary degree against the dead defendant. So my dad takes out no substitution application has been filed, but that has not been allowed. It was filed beyond the time. So it takes out an application. I prepared an application which has been affirmed to, and it will be filed.
You are for the defendant?
I am for the
Other
defendant.
defendants?
Other defendant. As the no substitution has been made, so I made an application to expunge the name of this particular defendant who died and then proceed with that appeal.
No, other heirs, his heirs are on record.
The heirs has not yet been substituted.
How can you expunge the name?
But he heirs has not been substituted. I cannot proceed with the appeal against a dead person. That is
No, you have to seek leave to prefer an appeal against the heirs of the deceased.
that application I have prepared. It will be filed during course of the day. Kindly take
You
it on
sought an
Monday.
adjournment on the last occasion also. Why
The
repeated
appellant
adjournment?
was ill. That is why I could not come to affirm it.
When should you keep it? Tell us.
Monday.
Monday, you'll be able to file it and give a copy to him. He's appearing for the other
It
side.
will be filed. It will be affirmed with during course of the day. So it
Oh,
will be filed
very
tomorrow.
Give a copy tomorrow then so that he can come. On the prayer of the appellant, let the matter stand adjourned till 21st, April 21, 2025.
Thank you.
Thank you. Next. Yes.
Decree, your lordship, I'm kindly praying for not this week, your lordship.
Why?
Your
So Martha has
lordship-
not come.
No, your lordship, for personal ground, he's out of station, your lordship.
But what I was, Lordship had already passed an interim order. This is an appeal from a final decree of partition. Let my learned friend kindly dispose of the application and direction be given for preparation of paper books, my lord, and notice of appeal may be dispensed with. We are all happy.
We had granted stay of operation of the decree.
On 11 March.
But don't give the name of Mr. Mahato. Blame Mr. Bhattacharya for this, for his appearance. He being deprived of the appearance. Heard learned counsel for the parties. The present appeal arises out of a final degree of partition. Degree was granted. Final degree of partition. Full next para. Upon hearing learned counsel for the parties and considering that the first appeal involves questions of both law and fact, comma, we are of the opinion that a prima facie case for hearing the appeal on merits has been made out. Accordingly, can 1 of 2025 is disposed of by granting stay of operation of the impugned decree, judgment and degree till disposal of the appeal. The you are for 2 and 3.
I am for the 1.
You are for 1. How many others are there?
3 only.
All are represented. In view of the appearance of respondent number 1 and respondent numbers 2 and 3, comma, through their respective learned advocates, comma, service of notice of the appeal on the respondents is dispensed with. Next para. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
But other defects are also there.
There are defects. There are defects.
Delay has been condoned.
Prior to passing decree, as computation of the period of limitation is possible. Decrees are done on non-judicial staff. The instead of
Non-judicial stamp paper করেছে একটা লাইন অ্যাড করে দিন the trial court decree be sent down immediately for effecting the necessary corrections as pointed out by the report of the additional stamp reporter dated April 13, 2024. So this will go down and the records will come up. Very good. আচ্ছা একটা লাইন অ্যাড করে দাও, শুধু একটা লাইন অ্যাড করে দাও। It is made clear that only upon the necessary corrections being effected to the trial court's decree shall the records be sent up to this court in terms of the above direction.
Kindly fixes that.
Otherwise, it will be difficult.
Kindly fixes the time frame, my lord. This is remand. This is remand from Supreme Court.
It is expected that the above orders shall be communicated immediately to the trial court and the necessary corrections shall be effected within 3 weeks from the date of communication of this order to the trial court.
This is an appeal under section against the order under section 25 of the Guardians and Wards Act and 12 also, my lord.
Service, you are not being able to.
Last occasion, your lordship recorded that his wife was not receiving. She has been contesting in the same address and she has not appeared in other proceedings also.
Yes.
That's why last chance was given by your lordship.
They're not appearing, so you move them.
Now, the section 5 application, my lord, there is a delay of 147. Reason for delay is the learned advocate who was given this set for work for settlement of the draft. He has undergone surgery, stated in paragraph 6 and 7, my lord. And prior to that, also petitioner was also contacted as a junior advocate, the senior advocate who was
upon considering this, the averments made in the application for condonation of delay, comma, we find that the learned advocate who was entrusted to prepare and file the appeal had undergone a surgery full stop, since we find sufficient cause for the delay having been thus made out, comma, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FMAT 364 of 2024. Full stop, next para. The appeal is deemed to stand registered. Full stop, next para. What is the ground for this? What you are the mother or the father?
No, I am the father.
Father,
I
yes.
had the application, but the girl child who is now 13 years old, she has been staying with her maternal grandparents. The wife admittedly does not stay with her. She resides at Delhi. Wife filed the written objection, but she did not come for not giving evidence. So I could not cross-examine her. And secondly, the minor child was not the judge did not interact with the minor child to know her desire. And last
Minus the child is of what is the age of the child?
now 13. At that time, not 5. At the time when this application was disposed of, not the 24th is 12. She was 12.
Now 13.
Yes. Not
She
she was 12. Now, admittedly, there is an interim order under section 12 for giving visitation rights. Not unfortunately, not for a single day I was allowed the visitation right, and that's why the Ranit Court also recorded that. That your lordship will find the visitation right is at page 53, and the Ranit trial court will not close the evidence because she did not comply with the order. Page 53, the final order of visitation rights. At bottom, petitioner father is entitled to have access to the daughter Akshita on weekdays, on Saturdays and Sundays, and will be entitled, if she child is willing, to keep with him on Saturday night for the said purpose. Petitioner father.
But ultimately, that has merged in the final order, and your
that is the final order under section 25. The visitation
25
right,
has been
the visitation
right. The interlocutory order passed on section 12 cannot exceed the main matter.
That the Ranit Court acknowledgement by
No, understood. You definitely have visitation rights,
Yes,
but that was not complied with, for which she got a penalty. I mean, her evidence was closed, but still, then you.
So I don't have any.
On merits, your section 25 has been now dismissed. So where is the scope of staying that order? No.
I'm not praying
for stay.
Only for visitation right. I'm just in an interim order. The
But you have to make a proper application then.
That the injunction stay application, although not in the
stay of operation prayer A, prayer B, pass such other. No prayer even. So you have to specify your. Will give you liberty to carry out that.
There is already recorded in the order other orders that she has been
violated. No, we are not averse to that, definitely. But since this is the application which was attempted to be served on her, now she will be under the impression that this
application section 5 only served. This application was not served.
Well, we are admitting the appeal and directing to carry out the necessary correction.
And yes.
No, but difficulty is.
That the final order also, that order is there. Page 90.
Necessary averments regarding.
Page 90 is already there.
Your prayer for visitation has to be supported by certain averments.
That is not here in the. This is there in paragraph 11. Paragraph 11. And in the final order also, that right is given. Page 90, final order. 25 order, it is there. Respondent will allow the petitioner to meet the child and accept gifts whenever the petitioner, father of the child, approaches her for the purpose.
In view of sufficient grounds having been made out for hearing the appeal, which is directed against the dismissal of the appellant / father apostrophe application for guardianship under section 25 of the Guardians and Wards Act, the appeal is hereby admitted and shall be heard on the grounds taken in the memorandum of appeal. Next para. Can 2 of 2024 has been couched as an application for stay, although, as per submission of learned counsel for the appellant, and it transpires from the tenor of the same, the same is substantially one for visitation rights of the minor child of the parties, namely Akshita Prasad. Next para. Leave is granted to the learned advocate and record for the appellant to carry out the necessary amendments to the cause title and the prayer portion of the present application by introducing appropriate prayers for visitation. A copy of the amended application shall be served on the respondent indicating that the same shall be listed same shall be listed for hearing on May 13, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Well, obviously.
Thank you.
Lord, may I just seek one leave, Lord?
Yes.
The mother is staying at Delhi, but she is
Delhi?
Delhi, right, and the guard is residing with her maternal grandparents. May I add the maternal grandparents in this application? Otherwise, they will be allowing. Mother is staying permanently at Delhi. But ultimately, we have to approach the maternal grandparents because of the peculiar situation. Or
very good. At this juncture, learned counsel for the appellant submits regarding a peculiar predicament being faced by the appellant. Full stop. Whereas the respondent number one, no, who is the pro forma respondent?
Child.
Oh.
Child.
Since the respondent number one stroke mother of the minor daughter of the parties is residing in Delhi and the minor child is at present with her maternal grandparents, unless the maternal grandparents are included in the appeal and the connected application, no effective order can be passed for permitting visitation to the appellant, even if such prayer is allowed. First up, we agree with the submission of learned counsel for the appellant and grant leave to the learned advocate on record for the appellant to amend the cause title of the memorandum of appeal as well as can 2 of 2024 by impleading the maternal grandparents of the minor child of the parties as parties to the appeal and the said application. Pushed up, the copy of the application so amended shall be served on the respondent number one as well as the added respondent stroke maternal grandparents of the child.
No, the amended to be made within.
We are not directing anything. We do it. We have given leave. Do it right now. You can do it right now. You have the addresses. By tomorrow, at least do it. Otherwise,
by tomorrow.
Do it by tomorrow. যেখানটা leave বলেছে, leave is granted to the learned advocate to carry out the necessary amendment by very well by April 21, 2025. Serve only after that.
Yes. Okay.
Item number 25, I am for the appellant.
Yes.
Earlier occasion matter was heard before your lordships, and I have served.
They did not appear on that occasion also.
My lord, I have served the learned advocate. The learned advocate.
Yes.
Expired, my lord.
Advocate has expired.
Yes, my lord.
Then you have to serve again on the. This application is carries allegations against that advocate.
Yes.
Why do you make allegations against the advocate? You have settled the draft.
Yes.
You don't make. Anyway, what is the? You have already served on the respondent.
Yes,
so what is the ground taken? The advocate did what?
My lord, kindly see, my lord.
Let us place the relevant paragraphs.
I am see, my lord. Kindly see me page 23 of the order of the learned advocate.
Item this is.
Kindly see, my lord.
This is. Yes, sorry.
Page 32, my.
32.
32.
This is an appeal against what? Tell us that.
Appeal against that, my lord. Learned court was passed.
Specific performance.
Yes, my lord. Specific performance. Yes. My lord, that the suit is the same as degree in part without cause. The plaintiff to get a degree.
What is the delay? What is the period of delay?
Delay, my lord. 2,284 days delay, my lord.
Let us see the relevant paragraphs in the application.
Yes, my lord. My lord, let me see the paragraph 5 of the continuation of delay, my lord. Being agreed and decided with the nature in the conduct by Mr. S.N. Gu, advocate the plaintiff in court from the other advocate of the said court of the the several complaints has been filed against him, the bar association, about his professional conduct, particularly attending with the other side of the supporting the case of the other side. The plaintiff in the year 2019 to take back the brief from the SN Guha, as he stopped to attend court for doing various illegal immoral acts, sitting in the court of the chamber of the and outside. Finding no other alternative, the plaintiff persons appearing in this case tried to convince the landed court pass the direction the judgment on debtor. The executive sealed it, and finally on 6/9/2024, landed court the judgment to make it clear that no order directing the judgment debtor or except the sealed it in favor of the plaintiff can be passed in view of the judgment and degree passed in title suit number 2 of 2002. Your petitioner state the London advocate for the plaintiff appellant to advise the widow the execution petition filed on order 21 rule 11 CPC by filing the application. And for that, the landed trial court should have held when the property stand in the name of the defendants and held by her. She is duty bound to execute the sale deed in favor of the plaintiff in the various agreement. And the sale deed by the landed court executed her.
Plaintiff is the appellant.
Plaintiff is the appellant.
Degree was passed in your favor.
Yes, my lord.
Why are you challenging the degree?
I'm the plaintiff.
We won't hear you since your client is represented through counsel. We won't hear him. You explain to us. You are holding his brief.
Yes.
You haven't ascertained why you are moving the appeal. You should know.
My lord,
you ask him and tell us. I mean, you didn't ask him even. You are the plaintiff. You obtained a degree of specific performance.
Yes, yes.
Why have you preferred an appeal against that? Did not occur to you before moving the matter?
Recently, my client in person moved the court before your lordship's.
You have recently taken the brief without knowing it. Please take instruction, come back tomorrow. Since learned advocate for the appellant is not prepared with appropriate instructions in the matter, let the matter stand adjourned till tomorrow. Full stop.
Tomorrow, my lord, personal difficulty, my lord.
Adjourned till July 21, 2025, next Monday. To the next para, the affidavit of, April 21, 2025. Since the affidavit of service filed today discloses that the erstwhile learned advocate of the appellant in the court below, against whom serious allegations have been leveled, for which we had directed a copy of the application to be served on the said advocate, has expired in the meantime, we choose to take up the, we have no other alternative but to take up the application in the absence of the said advocate. The affidavit of service filed today be kept on record. Matter Tasbe, April 21st.
Grateful.
Thank you. আমি তো ডিফেন্ডেন্ট ভাবে তবে দেখছি যে প্রিন্সিপাল অ্যাপ্লিকেন্ট চলে আসে বলুন
Excuse me, my lord. Learned senior counsel.
At last you have come with the right.
I made a
You are
mistake
sure
in
now?
sure now.
Affirm an affidavit and say that he's
I am sure now.
He's appealing for who? Appellant?
Appellant.
You are asking time till?
Time till 21st April.
You give your name.
Yes.
On the prayer of the appellant, let the matter stand adjourned till April 21, 2025. Thank you. Yes.
But this is an appeal challenging and decree of a divorce past ex party. May I just state your lordship the fact? Initially, my lord, I was contesting a divorce decree filed by my husband in the court of Barakpur.
Divorce suit filed by your husband.
Suit by.
Yes.
I stand corrected, lord.
No, sir. Yes. Then?
And that was MAT 1970 of 2018.
First of all, this is a Section 5 application.
This is a Section 5 application.
Have you served? Have you directed you to serve?
No.
Then we'll ask you to serve and come back.
Grateful.
In any event, you have to serve.
My lord, and in the list it is showing as defective, my lord. And
this is the defect.
That was the defect, out of time.
Let us check up whether there is any other defect. Have you checked up the memo?
Yes, my lord. The other defects has all been cured. My lord. There was an original decree which was not been filed initially. Thereafter, after your lordship's direction, we had filed. My lord, kindly takes up the order dated 16 December 2024.
Yes, yes, you have removed the defect. We will direct you to serve copies of both the applications directly on the.
Great.
The appellant shall serve copies of Can 1 of 2024 and Can 2 of 2024 on the respondent husband, indicating that the applications shall be listed for hearing. How soon can you serve?
1 week.
On April 28, 2025, when the appellant shall file an affidavit of service to that effect. Monday week it will be appearing. Monday week. So that if he, otherwise if he remarries in the meantime, that thing will be gone. Yes. Mr. Shur, what is the matter?
This is the suit for partition. First of your lordship, consider the section 5 application.
Delay of?
Delay of 247 days.
Opposing? Opposing?
Not properly explained.
Acha.
Let
Let him explain first.
Otherwise, I should.
Very much, Shakur, you understand. Take your seat. Yes, Mr. Shur, what is your explanation?
The explanation was the paragraph 4 and 5. That is the learned court below, the change of the advocate of the learned court. They did not disclose about the when the degree was passed. And thereafter, he came to the another chamber. Thereafter, he have obtained the certified copy and filed this appeal. This is the ground of.
You are the savior chamber.
Same chamber. That paragraph.
Same chamber.
4, 5, and 6.
Oh, your chamber only. Then it's all right. We won't direct service of cop. So no, then this is against what you said?
What you say?
Degree of?
Degree of the preliminary degree.
Of partition.
Partition. That is the learned trial court also decided only the Schedule A property. Schedule B property, there is no observation. And secondly, they have the defense number 6. I preferred an appeal. And
everything has been under the sun has been given. Why do you say no proper explanation? Financial stringency from starting from that law clerk communication.
That's what I have not. I will kindly see paragraph number 3 to 6.
Yes.
Fourth paragraph. Really has been explained.
Yes, 5 they have stated present lawyer met with previous lawyer.
Very beginning, they said that appellant petitioner obtain certified copy of the impugned judgment on 11/6/2024. Then
yes,
subsequently said that on the this is the only ground they
and when did they file ultimately?
For want of certified copy.
He has filed on the 24th February 2025.
So he approached the learned advocate of the trial court again applied. Very beginning he said that 11/6/2024 he obtained. Paragraph number 3.
That is kept pending before the clerk. That is it.
It was not your case. It was lying with the clerk or lying with the learned advocate. He obtained. Appellant himself obtained. And again he said, due to illness of the learned advocate on the court, it was not. It could not be filed. But again said, last paragraph. Kindly see. You have to go through the 4th paragraph. Lot of contradictions are there. Lot of contradictions. I am not on other things might not.
You're recording your opposition and that. The present application is one for condemnation of delay in filing the appeal. Because of the delay is of
246.
About 241 days as per our report. 241 days. So next para, learned counsel appearing for the respondent opposes. You are for respondent numbers 1 to 7.
1 to 6.
Check up, Mr. Choudhury, because up to 7 probably under the same bracket. 1 to 7. Learned counsel appearing for the respondent numbers 1 to 7 vehemently opposes the prayer and submits that contradictory statements have been made in the application for condonation of delay. Full stop. It is submitted that although admittedly the certified copies of the impugned judgment and degree sorry, were obtained by the appellant himself on June 11, 2024, the appeal was filed in the month of February next year. Full stop. Next para. Upon hearing learned counsel and going through the averments made in the application, we find that although there are certain minor discrepancies in the explanation, the reasons for the delay as given in the relevant paragraphs do not contradict each other as such or are not mutually exclusive. Full stop. The case narrated by the appellant in the application is apparently that after obtaining the certified copy, it was handed over to his erstwhile learned advocate, who was in laches in not filing an appeal, upon which a different advocate was approached. Full stop. Some time was apparently lost in handing over the papers by the previous advocate to the current advocate. Full stop. Also, the appellant faced financial stringencies and, since he is not an educated person, he suffered certain impediments in preferring the appeal. Full stop. Next para. Overall, we are satisfied with the sufficiency of the reasons in preferring the appeal late. Full stop. Accordingly, can 1 of 2025 is allowed on contest, thereby allowed on contest against the respondent numbers 1 to 7 and ex parte against the pro forma respondents, thereby condoning the delay in preferring FAT 90 of 2025. Full stop. There will be no arrest to cost. The appeal is deemed to stand registered and admitted. Can 2 is first stay?
Stay of the
This
learned trial court only dealt with the Schedule A property. Schedule B property has not been
Mr.
dealt.
Jagannath, what do you say to that? Can it be resolved at this stage?
Schedule A property, so all the parties were present. Schedule B property only it was dismissed for lack of for want of necessary party. One party was not added. Necessary party.
Then what will be given an opportunity to add the party before dismissing it? That is settled. If you agree, you can take instruction, you can come back.
You are the bench. I have added all co-sharer. I mean the pro forma. So I have added also serve all.
So far as Schedule A, it's concerned.
No, the schedule a plaintiff. Plaintiff is the dominus litis, although it's a partition suit.
They can.
What you could have you sought to add the parties.
In their in appeal court I have been added. In the suit where they have not been added.
Left out parties is one of their
co-sharer.
One of their co-sharer. But that is something. But so far as the Schedule A is concerned, let the decree be confirmed. Because it is a judgment of.
Achha, Mr. Chakraborty, if you confirm the decree regarding Schedule A and remand the matter regarding Schedule B, have you was the left out party ever added by anybody, either them or you? Not added. So we'll
not an iota of evidence was adduced by them. No documentary, no, not even oral evidence was adduced. Almost
but schedule regarding
statement. That's all.
Regarding Schedule B, there is an additional co-sharer.
Co-sharer, so far as B schedule is concerned.
B schedule is a different DAG, different.
That is DAG number 1.
Now, if that additional co-sharer who was omitted, he is not a co-sharer in respect of Schedule A, then Mr. This would be a misjoinder of misjoinder also.
And another point is, my lord,
Mr. Shud, we are telling you this. Suppose A has 5 co-sharers, B has those 5 plus 1. Then these two properties cannot be joined because we are telling you why. Because that X person, that X factor is not a co-sharer in regard to A. So how could these properties be added? We'll keep it open to the parties to file a fresh partition suit regarding B.
And another point is, my lord, that
we dispose of the appeal here and now. We affirm the decree.
My lord, in the A schedule property, they have not given any share. That has learned trial court given any share to the A schedule property. They have not discussed about the A schedule.
Given any share to you?
That is the defense number 6. That I prefer this appeal.
Oh, you have not been. That has to be decided.
No, nothing. That you see the degree.
Let us see the degree.
Let us see the degree. Defense number 6 has not been allotted any share.
No, why are you saying let us see the degree? You have already seen the degree.
So I'm seeing.
Let us see the degree.
Kindly see that it is hereby declared the plaintiff.
Fail to prove that he has got a say.
Then that has to be said.
That is the difference.
Iota evidence of
That has to be said. No, that requires.
No, expedient.
No.
No, iota evidence.
No, that is not the difference.
No, this is final degree has been passed.
No, final degree.
Preliminary degree.
Yes.
No, we'll pass the usual order. The final degree proceedings will carry on. Oh no, final degree will be drawn up without our leave. That order will suffice. Can 2 of 2025 is an application for stay. First of the appeal arises out of a preliminary degree of partition. First of the primary grounds of challenge is that no share of the defendant number 6 was allotted in respect of Schedule A property, whereas the learned trial judge refused to pass in a decree in respect of Schedule B property on the ground that one of the co-sharers to such property was not implemented. Pushed up, learned counsel for the appearing for the plaintiff stroke respondent numbers 1 to 7 submits that the defendant appellant did not adduce any evidence and failed to prove his share in the property. Moreover, with regard to Schedule A, there cannot be any impediment in the impugned decree being fructified. Also, regarding Schedule B, it is doubtful as to whether the said property could be joined along with Schedule A in the common hotspot of the partition suit, since Schedule B property has an additional co-sharer who is not a joint owner of Schedule A property. Be that as it may, in view of the above questions having arisen, the appeal is required to be heard on merits, and as such, a prima facie case for hearing for grant of stay has been made out. Next para. However, considering that the partitions that the subsequent stages of the partition suit is pending, we dispose of Can 2 of 2025 by directing the learned trial judge to continue with the final degree proceedings. However, the learned trial judge shall not draw up any final decree without the prior leave of this court till disposal of the appeal. In view of the appearance of the plaintiff's respondent numbers 1 to 7 through their learned advocate, service of notice on the said respondents is dispensed with. The appellant shall put in due requisites for service of notice of the appeal on pro forma respondent numbers 8 to 227 within a week from date. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The learned trial judge, however, shall retain a skeletal record for the purpose of continuing with the final degree proceedings. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Of liberty to the parties to mention the appeal for hearing as and when the same is ready for hearing. Prothom line, affidavit of service filed today be kept on. Status quo, nobody has prayed.
No, status quo, I prayed only that.
Status quo is very risky. They'll oust you tomorrow and say that you are in court.
Tag number 126 and 127, then I have to make a fresh application. That is, I cannot operate my fertilizer from the cultivated land.
Trouble when we take up your application for injunction. Yes.
Yes, I am for the appellant, my lord.
Please be a bit loud. We can't hear you, Mr. Bagchi, properly. Just amp up your. Yes. Now it's proper.
My lord, I am for the appellant. Copy served, my lord.
Yes.
And affidavit service, my junior is there with the affidavit service. And my lord, there is a petition of condonation of delay for 57 days.
Yes.
My lord, you can take up the petition, my lord. My lord, there is some late for to obtain the certified copy, and my lord, the appellant is a serviceman in Indian Army. We cannot able to contact him to sign the appeal in right time, my lord. That's why, my lord, 57 days delay.
Very well. Affidavit of service filed today be kept on record. Despite service, none appears for the respondent. We find from the application for condonation of delay that the petitioner is posted is an employee is employed with the Indian Army and due to posting in different places could not be contacted for swearing the affidavit in support of the affidavit is not required for the memo.
My lord,
For signing the necessary
for-
papers for preferring the appeal in time.
Yes.
Full
Yes,
stop.
yes.
Being thus satisfied of the sufficiency of the reasons in the delay of about
57 days.
yes. Appeal report থেকে কিছু নেই 57 days in preferring the appeal, comma, can 1 of 2025 কত আছে 36 আছে office says 36 days delay
36 days delay, my lord.
delay in about number of days তে বলা থাকে delay in preferring the appeal, comma, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring the appeal. First of, there will be no orders to cost. The appeal be deemed to stand registered and admitted. Anything else? Any other application? This is against what?
This is against was the final degree in divorce.
Divorce should
divorce.
dismissed. Therefore, there is no scope. So we'll direct you to put in special messenger cost and all these things so that the appeal is expedited.
My lord can pass.
You have to put in requisites.
My lord, my
You
lord.
don't want the appeal to be heard out quickly.
Yes, my lord. Yes, of course.
The appellant shall put in postal requisites and other costs, postal requisites and costs for service of notice of the appeal on the respondent, comma, within a week from date. The trial court record shall be brought by special messenger, also at the cost of the appellant, to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, liberty to the parties to mention for inclusion in the list as and when the appeal is ready for hearing. You have to put in the special messenger cost. Should he grant you a fortnight's time?
My lord, 20 days.
তাহলে within a week যেখানে করেছি দুটোই within a month করে দাও, within a month from date.
My.
Thank you.
Master.
এর মধ্যে যুদ্ধ ফুদ্ধ লেগে গেলে দুটোই করো আর্মিতে আসছি if there's a war in between then you'll not be able to pay.
Item number 30.
Yes,
Lordship, I am for the husband appellant.
very good to know that. What is the application about?
Lordship, this appeal came up for hearing before Lordships on November 20, 2024.
Dismissed for default?
No, Lordship. Under the heading
How we are
Order
dismissing?
41 Rule
Order 41 rule?
Rule 11, Lordship, and this order was passed.
Whatever order was passed, now what
Lordship,
is this
application for preparation of paper books.
Very. What is the appeal against?
Lordship, against the dismissal of the divorce proceeding filed by the husband.
You are the husband, you filed the divorce, that suit was dismissed. Very. Did you direct it to serve copy of this?
No, Lordship.
In view of the innocuous nature of the prayer, comma, service of notice of the application on the respondent is dispensed with. The application is primarily for expeditious sharing of the appeal. Full stop. Accordingly, can 1 of 2024 is allowed, thereby directing the appellant husband to put in requisites and postal costs for service of notice of appeal on the respondent, comma, within a week from date. Full stop. The trial court record shall be brought by special messenger, comma, costs of which shall be deposited by the appellant also within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice. Date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention for inclusion in the list as and when the appeal is ready for hearing. এটা ফেরত দিয়ে দিন। Hey, sir, please take back your that copy of the order. এটা আবার সই করতে পাঠিয়ে দেবে তার নাম। আগের দিন হয়েছিল একটা কপি দিয়েছিল হ্যান্ডওভার সার্ভার কপি, এটা সই হয়নি বলে আবার
31 and 33, my lord.
31 and 33 action.
Yes, they are both my appeals.
Yes.
Your lordship recalls, my lord, suit filed, my lord, my learned friend.
Yes.
And my lord, I filed my defense.
What happened to your hand? Mr. Chakravarti is not responsible to you. Yes.
But he is, my lord.
Anyway. So, two appeals, why?
I'll tell your lordship, because one from the eviction decree and the other from counterclaim 33.
Now that is, my lord, filed subject to, my lord, liberty.
Mr. Chakraborty's client sued for eviction decreed.
Yes.
And your counterclaim for declaration that you are a tenant.
I am a tenant of a third party. It's a trust property.
Very well. Dismiss. So that's why two appeals.
Yes,
what are the
that's my
applications?
two.
What
So,
are
my lord, if, I want to show, my lord, for stay just one page.
you want a stay of the the eviction decree?
Eviction decree.
And there is no scope of stay of your declaration.
Counterclaim, because, my lord, why counterclaim was rejected, my lord, is that it says that there was an ex parte initial decree, my lord, against me, the defendant, which was challenged, my lord, in High Court. There, my lord, by an order, I was granted liberty to file written statement.
All
Now, my lord, along with the written statement, I filed my counterclaim. The learned judge says, my lord, that liberty was only to the extent of written statement. You could not have filed a counterclaim. So that is questionable. It is not maintainable.
It should be barred by limitation also declaration.
No, it wasn't, my lord, because the counterclaim for declaration.
Anyway, we'll look into that. If that point was not taken by the trial.
Says it's within limitation. But because of that, it is not allowed. That is perhaps very settled law, my lord, your lordship.
So if that be so, you say that your counterclaim was not taken up on merits at all. If it was taken up, there was a chance of you being held a tenant.
I would say so.
Have you got any rent receipt? We don't think so.
No, my lord, today, my lord, we are at the stage, my lord.
No. Yesterday, did you have any rent receipt?
Rent receipt, yes, we have. Exhibits are there.
Very.
Exhibits are there. And also, it's a Thika land, my lord.
But then we come to occupation charges. We'll direct Mr. Chakraborty to file opposition.
But, my lord, I say it's a Thika land. I am not even his tenant at all.
Oh.
And this was the learned judge had no jurisdiction also. Because the moment I filed a counterclaim, my lord, for declaration, that is a trust property, and he says it's a Thika property, it goes before the controller. This is my submission, my lord.
Yes, Ms. Banerjee, you have a point there whether they're entitled to these occupation charges. We appreciate that. But even then, we'll probably direct you to put in the occupation charges. Why we say this? Because to obviously secure the amount if they win. And as of today, this occupation charge is being directed as a condition of the stay.
Yes,
so why as a condition? Because if the stay was not there, they would be getting the eviction. So to compensate them from that. So therefore, we'll grant a stay for a limited period. We'll direct you to file opposition. We'll keep the question of occupation. But execution has been levied.
No. They have not filed.
So, my lord,
Yes, Mr. Chakraborty.
not filed execution as
Not filed. This is a stay of operation.
And it's a small space, my lord. We were paying 100 rupees, my lord, per
The two appeals arise respectively out of an eviction decree obtained by the respondent against the respondents against the appellant and against the dismissal of a counterclaim filed by the appellant for declaration of his tenancy rights in respect of the self-same premises. Full stop. Next para. Since questions of both fact and law are involved in the appeal, we find a prima facie case having been made out. Full stop. Accordingly, there shall be stay of operation of the impugned judgment and decree dated December 13, 2024, passed by the learned judge, second bench, Common City Civil Court at Calcutta, in title suit number 1908 of 2022, whereby the appellant has been directed to be evicted from the suit property till disposal of Can 1 of 2025. Full stop. Next para. The respondents shall file their affidavit in opposition within how much time? You have to disclose whatever occurs.
in 10 days, man.
I will give you 2 weeks. Within a fortnight from date, reply, if any, shall be filed within a week thereafter. The application shall next be listed on May 7, 2025. For some next para, it is made clear that the question of whether occupation charges shall be imposed as a condition for stay is kept open for being decided at the time of final hearing of the stay application. Thanks.
They're both 31, 33. But I'm
Yes.
33, there is some defect because
কি defect আছে? দেখি দেখি। এটা 33?
perhaps, my lord, the initial order was December, and then your lordship gave me liberty, my lord, in March. So maybe the delay.
Delay.
Yeah, that's because, my lord, I had filed.
You have to file a section 5.
Formality has to be done.
Formality has to be done. Section 5 has to be filed. 79 days delay.
No.
31 was released without any delay.
So when your lordship gave me the liberty, my lord, that was in March. From there, it is within time.
Anyway, since we have granted stay regarding the other appeal, Mr. Chakraborty, they are safe for the time being. একটা line add করে দাও. Leave is granted to the appellant to file an application for condonation of delay in preferring FAT number 163 of 2025.
Great.
Do that.
Great.
Mention, try to file it as soon as possible and mention it before the returnable date. And give a copy to Mr. Chakraborty. Father had an unannounced bench, so he had to sit on that. And yes, what is the matter? Call on the list.
Before your lordship takes up the matter, I am mentioning item number 17,
Yes.
where your lordship was pleased to grant leave to correct incorporating certain names which is not there in the memo of appeal. That defect has already been cured pursuant to lordship direction on 24th March 2025. It is my fault, my lord. I forget to point out to your lordship, my lord.
No, it has been cured in the.
Yes. 24th March.
We asked you.
Yes, my lord. It is
the
my
memo.
It is my fault.
So let that order be there, Lord.
Only that portion be deleted. That your lordship grant leave to correct the coastal. That is what that portion.
It's already been passed in open court. Let that leave be there. If you have already done it, then it's done. No difficult. Yes, call on the rest.
This is my appeal. On the earlier occasion, my lord, I submitted the affidavit of service. My lord has recorded that the caveator has received. Now, my lord, my application is for injunction. My lord, the appeal is against an order.
The appeal was to be heard.
My lord,
Consider that the both appeal and application we said. What is the appeal about?
Now, my lord, my suit for specific performance has been dismissed. My lord, holding, if my lord takes the impugned order, the court has held in a clause in the my lord, agreement, my lord, there is a quantum mention, my lord, 15 lakhs, my lord, which was court has treated it to be, my lord, as a liquidated damages or damages. Therefore, my lord has refused to pass the specific performance. Now, my lord, if my lord, this is on the interpretation of that clause. Now, my lord knows under the specific relief act, if a my lord quantum is fixed as a security of the performance, my lord, then it cannot be said to be a my lord amount, my lord, for non-discharge.
Which was the relevant portion of the judgment which yes. Any interim order has been passed?
No, my lord, in the suit, my lord, from this court, I was enjoying interim order till disposal. Now, my lord,
now the suit has been dismissed.
Now the suit has been dismissed.
Yes, what is the relevant portion?
Internal page 11 of the impugned order, my lord, turns to.
Yes.
My lord, from the bottom, my lord will find. My lord will find it is therefore clear that plaintiff have already received collateral security. My lord, in the middle portion, 15 lakhs, my lord will find.
Therefore clear, yes.
It is therefore clear that the plaintiff has already received collateral security amounting to rupees 15 lakhs and interest of the same amount is also been enjoying by them.
But the specific performance, so you had to purchase a property?
No, my lord, we were the tenants. My lord, the landlords wanted to, my lord, reconstruct the building. My lord, we agreed we will vacate the premises. On reconstruction, we will be given, my lord, position in the reconstructed building. My lord, and the areas were specified. Now, my lord, when at the time of injunction, when trial court granted an injunction, my lord, they came up, my lord, in this honorable high court. In this honorable high court, my lord, they produced a plan.
Your suit was for specific performance of that?
Of that.
They were not giving you position?
No, my lord, when we came to know that they were not keeping the space as, my lord, agreed in the terms, my lord, we filed injunction, the court granted an injunction, my lord, they come up challenging that in FMAT before this court. In this court, my lord, they produced a floor plan saying that we are keeping spaces. Now, my lord, be that as it may, my lord, court said very well, you go on constructing, but you will not alienate, encumber the property till disposal of the suit. Now, just a contrary stand has been taken in the trial court saying that that 15 lakh which was given as a security, my lord, is a my lord, portion to be calculated.
Security was given in terms of court, high court's order?
No, in the agreement. There was a condition that for performing, they deposit 15 lakh security with us. My lord, on giving us
that would be in lieu of damages in the event specific performance was not
that
granted.
is the consideration which trial court took. My lord, my respectful humble submission is, my lord, this is only for the securing the performance. If it is for securing the performance,
securing the performance means if the performance is not done, then ultimately that will
if my lord takes up the specific relief act.
Yes, specific relief act to the. Yes.
My lord, kindly takes up section 23 of the specific relief act 19. This is where, my lord, the clause requires an interpretation. May I just place it, my lord?
Yes.
Liquidation of damages not a bar to specific performance. A contract otherwise proper to be specifically enforced may be so reinforced through a sum be named in it
as the amount to be paid in
No,
case
a
of
contract otherwise purport to be specifically enforced, yes, may be so enforced, right?
though a sum be named in it as the amount to be paid in case of its breach and the party in default is willing to pay the same. If the court, having regard to the terms of the contract and the other attending circumstances, is satisfied, the sum was named only for the purpose of securing performance of the contract and not for the purpose of giving to the party in default an option of paying money in lieu of specific performance.
We are not saying that it is in lieu of. We are not saying that.
No.
We are saying collateral security. What is the meaning of collateral security according to you?
No, this is not a collateral. Court records the term collateral.
Oh, it was not mentioned as a
No,
collateral security.
No,
That is, we are proceeding on that presumption.
no.
Show us the agreement. Where
Yes.
is that?
My lord, kindly takes the application, my lord.
Yes.
Kindly takes the relevant portion, my lord. Give this. Kindly takes up, my lord, internal page, application page 21.
Mm-hmm.
My lord, paragraph 5. That it has been specifically agreed by the parties herein that a security deposit fund of rupees 50 lakh shall be received by all the tenants herein, which shall be paid by the landlords
as a collateral
security against the failure of commitments of repossession of tenants.
Yes.
But this security,
it's as a collateral security.
Yes, collateral. My lord, thereafter, my lord, kindly reads on, my lord. Commitment of repossession herein by the landlords, when the landlord will hand over the possession in favor of the tenants according to B schedule in the newly constructed building. At that time, the tenant will refund the said security money forthwith without interest. So, my lord, it's not a collateral security per se. My lord, this is where the interpretation comes in. My lord, it is as if, my lord, if they fail, my lord, it is compensating me. No. My lord, it's a security money for ensuring performance. That is section 23. My lord, it is not like that liquidated damages is calculated for non-performance or, my lord, or not unsatisfactory performance in other commercial contracts. So, my lord, this
is there is no ambiguity in the claim.
Now, my lord, kindly read the otherwise what happens, my lord, kindly sees. Kindly sees, my lord, the premises tenancy act which gives a ground if the tenant doesn't evict on building rebuilding, my lord, he is liable to be evicted. Now, every tenant who, my lord, adheres to the provision that yes, you very well merrily construct.
This is not a decree under that provision. You agreed to, you made an agreement with the landlord.
Exactly, my lord. Then entire agreement has to be looked into. My lord, we were agreed. My lord, it was twofold cases were made out. My lord, first they say we are not the tenants. Court found out we are the tenants, they are the landlords. Second case, they were made to force to enter into the contract. Court says no. Both the parties merely agreed to enter into the contract. What happens by this nature, my lord?
No, Mr. Chatterjee, we are probably speaking at cross purposes. We are not saying that this denies you the right to have a specific performance. Collateral security per se does not mean that you don't have a right of security specific performance. If this was a security, here no option is given to either of the parties that yes, they may waive this handing over of possession and this will be the alternative remedy. No, this is not given as an alternative remedy. This is why you have a security that they will perform.
They will perform.
And you can definitely seek a specific performance of performance.
Exactly. My lord, now court dismisses the suit.
Even if it's a collateral security does not necessarily mean that it's an alternative for the, that it was an alternative, there'd be no provision here for handing over possession at all.
Yes.
Then this provision, the last sentence would be redundant.
Yes.
Isn't it? Because security means, collateral security means that it's a security, they assure that they'll perform that part.
They will
But
perform.
if specific performance is not possible for some purpose, then you get that amount.
No, my lord, here, my lord, this is not their case that it is not.
That is what we are saying, that if it is not possible, suppose there was some supervening impossibility or they could
This is
not
not the
honor
case,
their
my lord.
contract for other reason.
This is not
But
the
this does not prevent you from having a specific performance. This was not in lieu of. Collateral security is not in lieu of. This was neither in lieu of nor in addition to.
Absolutely.
This was to be refunded. This was just a security for your their handing over possession. Only on that ground it has been refused.
Only on that ground. My lord, from that portion, if my lord reads on.
Page 11, yes. Please, yes, it definitely.
My lord, last portion, my lord, is very clear. plaintiffs are not entitled to get any relief by filing this suit for specific purpose, but they are entitled to forfeit the collateral amount of 15 lakhs.
No, but you have to then return that 15 lakh
I'm holding that money till date.
without interest.
Without interest, I'm holding that money.
All right. But what can be done? We did not fix the appeal as such for hearing.
My lord, in the meantime, my lord, kindly injuncts them from alienating, encumbering the property.
You have asked for that?
Yes, my lord, my application is to that extent.
The appeal has been preferred against the dismissal of a suit for specific performance filed by the plaintiff stroke appellants. Push up next para. In the agreement between the parties, comma, who were originally tenants and landlords respectively, comma, clause 5 mentioned that the respondent landlords were depositing a collateral security to the tune of rupees 15 lakh against the failure of commitments of repossession being given to the appellants by the respondents. Push up in the same clause, comma, it was mentioned that when the landlords would hand over the possession in favor of the tenants stroke appellants according to schedule B of the agreement, comma, in the newly constructed building, comma, at that time the tenant will refund the said security money forthwith, comma, without interest. Push up next para. However, comma, the learned trial judge, comma, while dismissing the suit, comma, proceeded on the premise that the collateral security was ample remedy to the appellants, comma, since they had the relief of forfeiting this, since the only remedy available to the plaintiff stroke appellants was to forfeit the said collateral security in the event possession was not handed over. Push up, however, comma, learned counsel for the appellant rightly relies on section 23 of the Specific Relief Act 1963 to the effect that such a security would not be an impediment in granting the relief of specific performance. Push up, in any event, comma, since the appellants submit that they are ready and willing to refund the security money of rupees 15 lakh without interest in terms of clause 5, comma, we find a strong prima facie case having been made out as to the learned trial judge having erred in law in construing the collateral security to be in lieu of specific performance and holding it to be an impediment in granting specific relief, specific performance. Full stop, next para. Accordingly, the appeal shall be heard on the above question and on all the grounds taken in the memorandum of appeal. Full stop. The since despite service none appears for the respondents, comma, can 1 of 2025 is allowed on contest, is allowed ex parte, comma, thereby restraining the respondents and or their men and agents by an order of injunction from transferring, alienating and or creating any sort of third party interest in the suit property till disposal of the appeal. Full stop. The respondent shall also remain restrained from changing the nature and character of the suit property till disposal of the appeal. Full stop. Next para. Since we have already observed that in view of a caveat having been lodged by the respondents and notice having been served on them, comma, no further notice of appeal is required to be served, comma, the appeal be treated to be ready as regards service, full stop. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date, full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival on the trial court records on the learned advocate for the appellant. Liberty to the appellant, to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. All the respondents have lodged caveat.
My lord, one advocate has lodged on behalf of all the respondents.
Right. Fine. Next.
My lord, I appear for the respondents in this matter, my lord.
Yes.
My lord, I am appearing for the applicant. learned advocate appearing for the applicant. Medical checkups, he is not come to the court. So I am prefer not today.
You are the advocate on record.
No, sir.
What should be done?
I leave it up.
Well,
My,
could you-
my 7-11 was allowed. Suit dismissed. I leave it up to your lordship.
We can probably hear out the appeal along with the application. 7-11. But they have to appear. When will he come?
My lord, he is my senior. And
Oh,
next week, my lord, or next, not today, my lord.
On the prayer of the appellant, let the matter stand adjourned for the day. In any event, applications are not taken up today, tomorrow first. So only adjournment for the day. Let us
Thank you, my lord.
Monday.
give your name only, not a senior. Yes.
Lord, I am for the appeal.
Yes.
Lord, on previous occasion, Lord, I handed over the affidavit of service.
Right.
Lord, that was, Lord, the item was delivered upon the, Lord, the.
Yes, yes. What is the matter?
Lord, the injunction application has been rejected. Lord, the ad interim order of injunction was granted. Lord, it was extended time to time. On the particular day, I filed one application for Lord the extension of interim order, but I was told that the other matter will not be taken up by the learned judge. And accordingly, Lord, thereafter the impugned order was passed vacating my interim order. Order number 22.
We have granted an ad interim order.
My lord.
Despite service, none appears for the respondent at the time of call. Full stop. Accordingly, we dispose of can 1 of 2025 ex parte, comma, thereby directing the parties to maintain status quo with regard to the suit property and restraining the respondent and or his men and agents by an order of injunction from interfering with the plaintiff stroke appellant apostrophe's possession in respect of the suit property and stroke or from preventing the access of the plaintiff stroke appellant to the suit to the common space, comma, staircase, comma, roof, comma, water connection and other common amenities in the suit property till disposal of the appeal. Full stop. In view of the short conspectus of the appeal, comma, the trial court records need not be called for. Full stop. The appellant shall put in due requisites for service of notice of appeal on the respondent within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books, informal paper books without comparing with the records within 6 weeks from date, comma, incorporating all the necessary and relevant papers thereto. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is otherwise ready for hearing.
Great.
You just incorporate the necessary papers, the injunction. Whatever you have incorporated, probably that would be sufficient.
Yes.
Plenty of annexed.
Yes.
They filed this is identity. No, they filed written objection.
I filed plain WS, the injunction application, written objection to the injunction
Sufficient.
application.
So you prepare a paper book with these documents.
Yes. Great.
Thank you.
This is contempt application. Lord.
Contempt application. Yes.
Lord, appeal is Lord from dismissal of my application for custody of 12 years old girl child, my lord. Lord, Lordship admitted appeal, paper books have been filed, and my lord, Lordship granted visitation right by order dated 26th November 2024, my lord. My lord, the Lordship will find the order at page 12, my lord. Child was to be brought.
This
Lord,
contempt is appearing for the first time.
Lord, first time, my lord.
Yes. What is the contempt? Yes. What did you direct?
My lord, visitation order granted by Lordship has not been. Child was to be brought in a certain park, my lord, on every Saturday, my lord.
Gitanjali Kanan. This was an. I mean, this was an agreed order, probably. The venue was agreed.
Yes, my lord. This
Semi-agreed.
Yes, my lord. On 15th March and my lord, 22nd March, which is on record, and thereafter, my lord, on 29th March, child was not brought here. And in the court, it was disclosed by the learned advocate when matter appeared on 24th, my lord.
Yes.
That child has been taken to Mumbai, where father is employed, my lord, without any permission, leave of the court, my lord. Said, my lord, that mother has granted such permission. No, my lord, mother has never granted such permission, my lord.
Serve a copy and come back. Since a prima facie case of contempt has been made out, insofar as the alleged contemner has apparently not abided by the order of this court directing visitation rights of the minor child to the appellant mother, comma, the petitioner shall serve a copy of the contempt application on the alleged contemner, comma, directly and stroke or through the learned advocate appearing for the alleged contemner in this court, and file an affidavit of service to that effect on the returnable date. Full stop. The contempt application shall next be listed on April 28, 2025.
Good.
Thank you. We'll file that affidavit of service on the next.
Yes.
I am for the appellate, my lord. On the last occasion, opportunity was granted to apply for certified copy in the lower court of the decreed order. Though we have applied on 20th of the for the certified copy order.
When did you apply? 20th?
20th March, my lord.
Achha.
But we yet not get the certified copy of the decree, my lord.
We are adjourning for another 4 weeks? To a fortnight?
4 weeks, my lord. Cause in the certified copy section, we have tried to file the locate the file. They are still in search, so we have not get the.
The learned advocate for the appellant submits that that although the certified copy certifies copies of the judgment and degree of the trial court have been applied for in the court below on March 20, 2025, comma, those have not yet been supplied by the concerned department of the trial court to the appellant. Push up accordingly on the prayer of the appellant, let the matter stand adjourned till May 13, 2025, a little more than 4 weeks. May 13, 2025, when it will be listed under the same head.
One thing, my lord, may I be just pardoned, my lord?
Pardon?
One thing, my lord, in the previous matter, I was just Mr. Mukherjee
Yes,
also pointed out. My lord has waived the notice of appeal being served. My lord, he has correctly pointed out the caveat is against the application. My lord, actually, there is no caveat against the hearing of the appeal.
No. Caveat is always against the application. But we had recorded in our previous order that by virtue of appearance through the caveat, service of notice of appeal is dispensed with also. Since they have appeared to that Vakalatnama. It was recorded in the last order.
Lordship, on behalf of the appellant, I am praying for 1 week's accommodation.
Why?
Lordship, I am led by Mr. Raut. He's out of station due to some personal reason.
When should he keep it?
Sorry?
When should he keep it?
After 1 week, next Wednesday.
Next Monday then?
Monday, not Monday. He will come.
On the prayer of the appellant, let the matter stand adjourned till April 23, 2025.
My lord, I am for the respondent. Well, my instance, my lord, the matter has come before your lordship, my lord. I have served notice before mentioning this matter, my lord.
In a order 41 matter, you cannot mention the respondent has no right of hearing.
Indulgence is my problem is that it is a preemption matter, my lord. But they are filing.
The respondent doesn't have a right of hearing, and nor does he have a right of inclusion in the list. If they don't appear, we'll just let it go out of the list. Respondent, are you suffering? You cannot suffer in injury anymore.
Suffering.
How can you? Order 41, it has not been admitted as yet.
Suffering means that, well, this is a preemption case. It is maybe revision. Both hard, it is revisional matter.
Preemption case under section 8?
Yes, my lord.
They filed.
And my lord, thereafter.
This is item 39.
39. Now, my lord,
what are you saying?
Going to enjoy the property, my lord, they are disturbing constantly and saying there is a file before Honorable High Court. Last 2 years, my lord, we are suffering the same problem.
Oh.
Yes.
A judgment of affirmation, my lord.
Oh. Right. Well, you have served a notice on the appellant's advocate.
Yes, my lord.
File that.
This is the Xerox copy. I have also the original.
Where is the original? File the original. ওটা ফেরত দিয়ে দিন।
This is the original.
Although under normal circumstances, the respondent does not have a right of hearing at the stage of hearing under Order 41 Rule 11 of the Code of Civil Procedure, in view of the appeal not being palpably maintainable, we entertain the mentioning, particularly since a prior notice of such mentioning has been given to the learned advocate for the appellant, which is evident from the receipt filed in court today, which is kept on record. Next para, the appeal has been filed against a judgment of affirmance passed in connection with a proceeding under Section 8 of the West Bengal Land Reforms Act. Next para, since no second appeal is provided for against a miscellaneous appeal preferred against an order passed under Section 8 of the said Act, the present second appeal is ex facie not maintainable. Accordingly, SAT 152 of 2023 is dismissed as not maintainable without any order as to cost. Next para. No application filed in connection with it.
Nothing, man. Last 2 years they are taking nothing.
This much, please. Thank you.
Apply for the appellant, my lord. There is an issue with regard to deficit court fees, my lord. I've paid.
Paid?
But probably revised report has not come. That's why it's still showing as DCF.
So let us just check up.
At the bottom, my lord, will find file DCF.
This second page?
Second page, probably, my lord. DCF, deficit court fees at the bottom. File Vakalatnama and memo. After that, my lord, second.
At the bottom?
My lord, may I just
Just mark it and hand.
Yes, yes.
Or show to our officer and just.
Yes, ma'am. 885.
Very well. Learned counsel for the appellant hands over the photocopy of information obtained from the
e-court services.
e-portal.
E-court services.
E-court services, from which it is evident that the deficit court fees have been deposited by the appellant. The appeal shall furnish a revised report in that regard. The appeal is taken up in view of such defect having been cured, the appeal is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes.
Very well, ma'am. So I'm for the principal defendants, the other appellant before your lordship. Judgment of affirmance, suit for declaration of title and permanent injunction. Now, my lord, admittedly, the suit plot 886, which is measuring about 36 decimal, admitted facts. My lord, I'll show from the. May I just submit first, then?
Submit first. Please repeat.
Plot number 886 is the suit plot, which measures about 36 decimal.
Right.
And the suit property is 4 decimal out of the 36 decimal. Now, Exhibit 1, as used by the DW1, shows that the suit plot belonged to three brothers in Ejmali. There was no partition. Amicably, they were in.
Plot means entire 886.
886. Now, Exhibit 1 on behalf of the different DW1 shows that. Now, there was no partition. One of the brothers, who was my predecessor, allegedly sold out a portion for that 4 decimal portion to the plaintiff's predecessor.
Plaintiff is an outsider to the family.
Outsider to the family. Now they have filed a suit for declaration and permanent injunction alleging I have been disturbing his possession.
Declaration of their exclusive title regarding that 4.
Regarding that 4. Now, my lord, in the PW1, it is four things are admitted. Evidence is before your lordship. He admits that the defendant are co-sharer in respect of the remaining 32 decimals. The 4 decimals they have paid declaration for. Now, he even admits that the plaintiffs are not in possession of the suit dug number. They are in possession of 887. Categorical admission. Not, no, my lord, it is further admitted the defendant in possession of the suit plot. Now, it is also admitted they used the suit plot as a easementary right to go to 887. Now, it is further admitted the suit property was never partitioned by meets and bounds.
Show us only that admission.
My lord.
The last one.
My lord. My lord kindly sees the entire certified copy.
How did the courts deal with it? What was the?
I had admitted that the brothers had a amicable settlement with regard to the possession. They will be possessing the separate shares. The court admitted, since I have admitted the amicable set partition, the court passes a decree and does not consider the admission made by the PW1 that they are not in possession. A decree of permanent injunction has been passed.
Have you admitted that amicable partition was given effect to?
No, there was an amicable settlement between the parties with regard to their possession.
Start with that admission, where that has been done. Your admission. We'll come to the other one later.
Now, my lord, with regard to that admission is only in my written statement. And may I show the PW1 first?
Let us see how the courts dealt with it.
My lord.
Either of the courts?
Yes, my lord. My lord will find the judgment.
Have you annexed the entire certified copy?
It was
applied like that. Apply for judgment degree separately.
It was obtained like that, my lord.
Obtained because it was applied for. Certified copy always apply for separately. Judgment degree separately and the rest of the documents in a bunch.
Yes, my lord.
It's a difficult time finding out. We are starting with an injunction application being allowed.
No, my lord, that is all orders of the suit.
Obviously, don't do it.
Sorry,
That is the appeal court judgment.
Appeal court's judgment, my lord, at the bottom.
Appeal court should be in the memo. Appeal court, we are giving us some free GAN.
Yes.
Appeal court judgment first, then trial court judgment, then appeal court degree, then trial court degree in memo. Paper
This
book.
is in effect a paper book in
Paper
itself.
book reverse.
This is
Yes.
in effect.
You know that then. Yes. Let us see the appeal court judgment
Yes,
first.
my lord, at the last bunch of certified copies. Title appeal number 32 of 2022. 36 of 2022.
Yes. Which page should you look at to find that how it was dealt with?
My lord, points of consideration, internal page number 5, decision with reasons.
Got it? Oh, sorry. Internal page 5 দেখাচ্ছে, last দিক থেকে। আপনি যা করছেন তো? Yes, continue.
My lord, last paragraph from bottom. It is undisputed that Muchiram Parui was the absolute owner of the property which he got by way of amicable partition between the brothers.
Muchiram Parui was
my predecessor in interest. And they were 3 brothers. Now, from Exhibit 1, the certified copy of that part I'll come to later. And 4 decimals of land in plot number 886 was transferred to Kiran Shankar Sarkar, son of such and such.
But if you admit amicable partition, there are several judgments. The parties, if it's a family arrangement, the parties are bound. You are stopped from challenging.
With regard to possession, there's an amicable settlement. That doesn't mean, it doesn't ipso facto mean
amicable partition.
That does not tantamount to a partition. Partition has to be by meets and bounds, by way of a decree of a court or by way of a deed, registered deed.
No, there are a line of judgments. Several judgments are there that which say that, see, amicable partition, yes, partition has to be by meets and bounds, either by a decree or a partition deed, registered deed. But if there is a family arrangement between family members, then they are stopped from challenging that partition.
It was their allegation. They
are stopped. As against the whole world, the rest of the world, yes, degree has to be there. But you have a point that it's a plaintiff suit. So
it's their onus.
You are in your appeal. You are stopped from taking that defense, because if you have admitted there was a amicable arrangement between the 3 brothers.
The amicable arrangement ought to have been with regard to 12 decimals each. The suit property is of 36 decimal. The 4 decimals they allege they have been sold.
Amicable partition. What was the?
There's nothing. There's nothing came
Show
for.
us your admission. Do you have that evidence?
Yes, my lord.
Certified copy of the
Yes, my
evidence.
lord, I have the evidence.
Where is that?
Separate.
Then it becomes a plausible view. That is the difficult.
Now that apart, the possession has been admitted to have been with the defendants. The plaintiffs admitted they have no possession. The decree of permanent injunction could not have been passed. But I'll come to the declaration part, my lord. This is all evidence certified copy, my lord.
This is PW1.
No, my lord, after that, my lord,
এটা হচ্ছে the report.
my lord will find date 3rd of July 2018, the cross-examination date.
Yes.
At
Yes.
the fifth line from the bottom, my grandfather and father were in occupation of plot number such and such. And so we are occupying and residing therein.
No, where is the amicable partition admission?
No question are put forward to by the plaintiffs with regard
No,
to
where
that.
where is your admission? You said there is an admission that there is a
Written statement, only in written statement, isolatory statement in written statement, my lord. That is in CAN application, that is annexed with the CAN application. Page 23.
Second question is the position admitted to position. In the absence of any. They did not pray for recovery of position at any point of time.
No.
Where is their admission regarding position?
No, my lord, PW1.
Yes, which part?
My lord, I'm just PW1, which was resumed on 15th of February 2017.
Yes, we find that.
My lord, from the top, it is 1, 2, 4, 5, 6, 7, 8, 9. 10th line, we. It starts from we. We are residing in plot number 887. The defendants are residing in plot number 886. It is a fact that we travel through plot number 886.
The present second appeal will be heard on the following substantial questions of law. One, whether the courts below substantially erred in law in granting a decree of declaration of exclusive title of the plaintiff stroke respondents in respect of the suit property despite partition by metes and bounds, either by way of a registered deed of partition or a partition decree, having been proved by the plaintiff stroke respondents. Roman 2, whether, in the teeth of the admission of PW1 as to the plaintiff stroke respondents having no possession in respect of the suit property, the courts below were justified in granting a decree of permanent injunction. 3, whether the courts below committed a substantial error of law in decreeing the suit in the absence of any prayer for recovery of possession having been sought by the plaintiff stroke respondents. Any connected application?
No, there's an application for injunction. Since there was only, in the meantime, they have already prayed for an execution. It has to be, the judgment decree has to be stayed, because I was under the impression the execution would not be have
your application prays for a stay.
My application prays for an injunction from the creation of third party interest. Since there was only declaration, there was no execution at that point in time. Subsequently, I'm come to learn.
Where is your application? We can't find it.
My lord.
Application to go. Thank you. And you have to file a proper application for
Yeah,
that.
so I have to take
We'll
out
give you
that.
that liberty, we'll grant you injunction for the time being.
Kindly records that the execution has been levied upon my submission, my lord, so that I
So
can
levied, execution levied regarding the injunction,
the injunction, permanent injunction, my lord, and my possession is being
will
disturbed.
grant you status quo regarding possession.
I'm grateful, extremely
So
grateful.
that would help you for the time being.
Yes, my lord, I'm extremely grateful.
In view of a prima facie case having been made out, since the appeal has been admitted for being heard on the substantial questions of law as formulated above, we are of the opinion that unless an interim order is granted as prayed for, the appeal is at the risk of being rendered infructuous. First of also, we find that the balance of convenience and inconvenience and the irreparable injury elements operate in favor of grant of an injunction. First up, accordingly, the parties shall maintain status quo as regards possession, nature and character, and creation of third-party interest in respect of the suit property till disposal of the application. First up, the petitioners shall serve copies of the application on the respondents. Respondent numbers 1 to 7, indicating that the application shall next be listed on May 6, 2025, when an affidavit of service to that effect shall be filed by the appellants. Service of the application on the pro forma respondent stroke opposite party numbers 8 to 10 is dispensed with for the present.
I'm grateful, my lord.
Thank
Lord, I might be, my lord, doesn't this go before the single bench after admission, my lord?
Yes, thank you. যেটা বললাম, হ্যাঁ, যেখানে বললাম be listed before the appropriate learned single judge having determination, subject to being mentioned before the said bench. Thank you for pointing.
I apologize, my lord. May I have the evidence certified copy, my lord? I handed over.
যেটা দিয়েছে দিন।
I'm
You have
extremely.
annexed everything in any event.
Yes.
It is certified copy hand over.
That will be kept with the record. That is the court fees. There's other.
That original certified copy দিয়েছে। You handed over this only, or this? Yes.
I'm extremely grateful.
Thank you. Next.
I beg to appear on behalf of the appellant.
What is the defect, first one?
The defects are, my lord, as I have annexed, my lord, the decree and judgment. Of the
Middle name of the sole appellant is not there in the appeal, in the decree.
My lord, I tell you the reason behind. My lord, I am
You have introduced Kumar.
My lord, that Kumar, my lord, not as per, my lord, my.
No longer a Kumar.
My lord, my Aadhaar card, my lord, reflecting Kumar. So, my lord,
You should have written alias.
I was
that would have
told by
taken
the
care.
series, my lord, I could not write alias because there was no alias in the trial court record, my lord.
But you could write Kumar, although there was no
only
Kumar.
at the instance of, my lord, the oath commissioner, my lord. Otherwise, there was a problem.
Learned bench number of lower appellate court mentioned in the preamble is erroneous. What is bench number? It was not the 7th bench.
Yes, my lord. Appellate court, my lord.
Second bench.
Second bench, presidency, small causes court, my lord. And city court, my lord, 7th bench.
Oh yes, right. Second bench of this, right. No, 8th bench. It's written 8th bench on the cover page of the 8th bench. It's 8th bench, not 7th bench. Roman 8, not Roman 7. There are 3 lines after the V.
No, my lord, I'll get it corrected.
Rectify. We'll give you liberty. But what about the other thing? The Kumar you have to introduce alias somewhere. And the third is judgment date of trial court furnished in the preamble. Very well. The date of the judgment of the trial court is also wrong.
No, my lord, probably not wrong, my lord, because
you have stated 21st of June 2019.
21st of August 2019.
Then that's an error.
That is Presidency Small Causes Court, 1990.
Presidency Small Cause Court, that was dated.
Then
August.
Court order.
Actual date is August 21st.
My lord.
You have stated in the preamble June 21st. So rectify all these things.
My lord.
This is a second appeal.
My lord.
We'll hear right now under order 41. Even if you dismiss the appeal, please carry out the necessary corrections.
As your lordship.
Leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal in terms of the defects as pointed out by the additional stamp reporter by the report dated, VDA report dated May 2, 2024. during the course of the day. Do that either way. What is the appealable?
My lord, the suit is for eviction, my lord.
Yes.
The trial court, my lord.
You lost, suffered the
lost,
degree of eviction.
my lord. Then,
Eviction
my lord,
on
that
what
was
ground?
On reasonable requirements, my lord.
Only?
Only, my lord. Reasonable requirements, and the reason was that requirement was reasoned for as such that for garage. But it is evident from the four corner of the record that with that accommodation, the plaintiff purchased the property. Then soon after purchase, my lord, he has brought that suit, my lord, against me. Despite of the fact, my lord, there is no provision for garage, and he at the time of initiation of this suit, my lord, he does not have the car with him.
Not necessary.
He does not have the
finding reasonable
and during pendency of the suit,
one may subsequently wish to buy a car. He need not prove.
subsequently purchased, and he kept it, my lord, with different accommodations. So, my lord, we
What can he do if he doesn't have? You don't give him his own premises.
So, my lord,
It's a ground floor flat.
It is. I am using the ground floor.
Then that is sufficient.
I am using ground floor.
What is the substantial question of law here?
But that part has not, because there is no provision, because the road condition, the road, there is, and the height from the ground to the first ground floor height.
We have dismissed an appeal up to 3 feet height difference from the pavement, saying that they can create a ramp if they want.
And the car cannot be moved from the commissioner report. It is.
How did the courts deal with it?
My lord, there is no dealing so far as that part is concerned. I have taken that.
Commissioner report you must have annexed with your application. If you rely on that, you have to annex that.
My lord, may I come with supplementary affidavit annexing commission?
Have you got a copy of the commissioner's report with you now? Yes. Give us that copy. Without that, how could you drop the memorandum of appeal? What are the dimensions of that room?
And there are also other room on the ground floors. He choose to.
That is his choice. He has those rooms, or those are also tenanted.
No, those are one room is with him, and some of the rooms are accommodated with tenants. This is the commissioner report. One copy.
Hand over. One of us will see to run the risk of the other one dismissing. দেখুন এটা কমিশনার রিপোর্টে যদি দেখতে পান কমিশনার কি বলে সুটরুমের সাইজটা কত দেখুন সাইজ বলছে কিছু না না এটা না এটা which room number is the suite premises specific number
there is no
another tenant so দেখুন another tenant করে রয়েছে দেখলে another tenant রয়েছে ছেড়ে দিন এটা তো অফিসিয়াল হিসেবে এই আছে আর 13 feet 13 feet by এই রাখা পক্ষে যথেষ্ট তাই না 13 by 9 9 feet 10 inches মানে almost 10 Other rooms are all tenanted.
My lord, tenant.
All tenanted. And your room is 13 feet by 9 feet.
My lord.
So he requires 8 by 12. He gets 9 by 13.
And he has, my lord, accommodation, my lord, within the vicinity, my lord. Keep the.
We don't get it from the commissioner's report. Any other accommodation, all are tenanted. He's a structural engineer. He requires a car. He can modify that much. That two feet plinth level difference. That is the finding of
Issue number 6, my lord. If your lordship takes up, my lord, issue number 6, my lord, the trial court order.
issue number 6. That is the whether he reasonably requires. Please come to internal page 8 of the trial court. Plaintiff is a structural engineer having inspection of different sizes. He requires car to attend service of clients, and car necessities. I mean, it's included in everything. At the locality of the no vacant garage space. So
that is his case.
Everything is there. His case has been, I mean,
Milord,
fortified by the commissioner's report.
Milord, that is his case. Milord, extract from.
No substantial question of law, sir. Sorry.
He has not mentioned his place regarding the number of family members. Milord, kindly take some page.
Family members is not required. There is only one vacant room in the on the ground floor. So family members.
That before purchasing the property.
Only family member required to be seen is the car.
No.
No other family member.
He is accommodation, Milord, within the, Milord, and the 4 Golab Shastri Lane, Milord, he was residing there.
Which premises? Same premises?
No, not same.
He will reside here and he will park the car elsewhere, some other place.
But Milord, car park, Milord, the car, Milord, cannot.
Glasses come out.
Milord, the car cannot move into the, Milord, the lane, Milord.
There is no such indication in the commissioner's report.
Milord, I have taken this in mind.
We cannot look into that. And this is a concurrent finding of fact. It has to be perverse or a legal inference which could not be drawn by a prudent man.
Milord, my case has not been, Milord, considered by that appellate court also, Milord. That
What case? You had opportunity to lead evidence. No contra evidence is there. That there is, yes, there is another room vacant, or I mean, it is impossible. Any report by an engineer from your end? Nothing. Dismiss করে দিই। ওটা একটু দেখে করে দিই। Sorry, but carry out the corrections in the memo. The present second appeal has been preferred against a judgment of affirmance, whereby both the courts below granted a decree of eviction against the appellant on the ground of reasonable requirement of the plaintiff stroke respondent. Push up next para. Learned counsel for the appellant seeks to impress upon the court that neither of the courts below considered the contention of the defendant stroke appellant that it is impossible for a car to take entry due to the limited width of the entrance of the suite room and the absence of feasibility to use a room as a garage to that extent. For sub next para, moreover, it is argued that the courts below failed to take into consideration the difference of height from of the suite room from the road level, which makes it impossible for the said room to be used as a garage. So also, it is contended that the plaintiff is in occupation of sufficiently suitable alternative accommodation for which the decree should have the suit should have been dismissed. So next para, however, we find from the commissioners, you have to have hand over a copy of this. We'll keep one copy on record. However, it transpires from the commissioner's report, a copy of which is handed over in court today by learned advocate for the appellant, that the rest of the rooms owned by the plaintiff respondent on the ground floor are occupied by tenants. First up, next para, there is no other accommodation of the plaintiff room at the suit premises itself. First up, since the requirement of the plaintiff respondent, as pleaded and proved, is for a garage to park his car, we cannot agree with the learned counsel for the appellant that an accommodation, comma, even if available elsewhere than the suit property would suffice to meet such requirement, comma, since no effective purpose would be served if the garage is located elsewhere than the residence of the plaintiff. First of that apart, comma, the difference in plinth height of the room from the road level being 2 feet 1 inch can very well be mitigated by the plaintiff, comma, who is a structural engineer and seeks to convert the room into a garage. Full stop. There are several architectural methods available for doing so, such as construction of a ramp and or other ancillary measures, comma, which the second appellate court need not go into in view of the concurrent findings in that regard returned by the courts below. Full stop. That apart, comma, the dimensions of the room sought by the plaintiff for use as a garage space was 8 feet by 12 feet, whereas the dimensions of the suit room is 9 feet 2 inches by 13 feet, and the height of the suit room is 9 feet 10 inches, comma, which would be sufficient for parking a small car. Full stop. Next para. In such view of the matter, comma, we do not find any patent perversity or substantial question of law being involved in the present appeal. Full stop. Accordingly, SAT 79 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. You have filed any application? Yes. Can 1 of 2024 is accordingly dismissed as well. No order is to cost. A copy of the commissioner's report handed over in court to be kept on. Sorry. Please carry out the necessary corrections. Yes. Next. Yes. But 2 appeals, Mr. Mukherjee?
But one cross objection was there before the first appellate court.
Give us the background. Yes.
The defendant is the appellate.
All of you are appearing for the respondent. Admitted on that ground. Yes. Yes, what is that?
Except SAT 144.
Concurrent finding. I mean, affirmance.
The reversal. The suit for eviction initiated on the ground of default reasonable requirement. I am the defendant. I am the defendant in the suit. Initially the property was belongs to the single owner. He ultimately gifted the property by virtue of a deed alienating he died the 4 sons ultimately the property got by them, and
Yes.
they have partition thereby meets and bounds delineating what portion they will get. Out of that the plaintiff's father got a specific demarcated portion in the 3rd floor. That is the suit property in question. Initially there was a lease whereby the 2 of the rooms was occupied by a separate person. After the suit being initiated, they have got possession in respect of 2 rooms. This is in respect of 3 rooms and covered by 1 bath and
Those
privy.
2 rooms also on the 3rd floor must be.
Yes.
How many total rooms in total on the 3rd floor?
Total it's 3 and 2 it's 5 in number.
5. 2 he got occupation possession during pendency. His requirement was
Plain pleaded that he has already got possession in respect of that 2.
very well.
That suit initiated. Ultimately, the suit dismissed on the ground that the property was erroneously described. The suit property. Instead of 3, it should have been 4. That is rooms. That is the one of the ground. But in respect of the reasonable requirement, the learned trial judge found that the plaintiff reasonably required the suit property. That's why the
would have been given an opportunity to amend his schedule.
That is
Anyway.
neither here because
So
I
on
must be
reasonable
candid
requirement,
before your lordship.
It's a concurrent finding.
Single room that is in respect of 1 kitchen. The first appellate court finds that since it's a kitchen, so the suit property has been described as 3 rooms along with 1 bath and privy. So it cannot be said to be an erroneous description for which the suit can be dismissed.
Right.
That is one of the findings. I must be candid. What is the ground I wants to agitate? The plaintiff is residing at England. He has a separate house he has owned in Liverpool. He has filed the suit by his aunt by virtue of a power of attorney alleged to have been executed by the plaintiff. Pursuant to that power of attorney, this suit is being initiated or instituted by the aunt. The first point I want to agitate before your lordship that the Power of Attorney Act, my lord, provides, my lord, section
There's
2 of the
there's an act by such name.
yes.
Yes. What does it say?
My lord, the section 2 said, my lord, it has to be, my lord, executed and signed by both the, my lord, the appointee, my lord, and the attorney. My lord, it's
So
my
try
lord,
to hit at the root of the filing of the suit.
yes. My lord, here, my lord, admittedly,
You take the point ever.
The trial court, yes, my lord, I shall show before your
Anyway,
lordship.
let us
The
continue.
trial court, my lord, has, my lord, this point was taken that this has not been signed by the donee. My lord, the language used, my lord, donor and donee, my lord, in the act, my lord, I shall show before your lordship. It has not been signed by the donee. My lord, this aspect of the matter has not been dealt with properly.
So the constituted attorney did not sign it.
Yes, did not sign. But my lord, she
acted on that.
She acting as a attorney, my lord, she filed the suit.
Yes.
So, my lord, it's not about, my lord, the appointer, my lord, has signed the document, but the appointee, my lord, the attorney. Attorney also, my lord, has to, my lord, sign. My lord, in absence of that signature, my lord, it's not a simpliciter, principal and agent. My lord, there are, my lord, certain, my lord, distinguishing view, my lord, once it's a principal and agent, my lord, they need not, my lord, even sign. But once, my lord, as an attorney, my lord, your lordship knows, even for an attorney, I can sign and execute a deed on behalf of my appointer. Like, my lord, the filing of wakalatnama or filing of a case before the, my lord, court. Initiation of legal
But the
proceedings.
acceptance
So
was evident from her acting on the basis of that power of attorney.
Yes.
In that context, why shouldn't that provision be dealt to be treated to be directory?
Lord, may I just place
If you cite any judgment that is mandated.
Lord, I must be candid. Lord, this mandatory part, Lord, I could not able
Cannot
to
be
lay my hand.
mandatory. She acts on that power of attorney. Mr. Mukherjee, she files the suit, gets a decree on the basis of that power of attorney. Anyway, this is your first point.
This is my first
What
point.
is the second point?
Second point, my lord, it's, Lord, in the, Lord, the name of the brother, my lord, may I just give your lordship the original owner. Subhash Chandra Sen is, my lord, the original, my lord, owner. He died, leaving behind his wife, Kollani, and, my lord, and
four sons.
Four sons.
Yes.
Four sons, my lord, the Subhash, Prithish, Prabhash, and Oporesh.
Who is their predecessor?
Yes.
Who is their predecessor?
My lord, here, my lord, the predecessor is Subhash Chandra Sen. Plaintiff's predecessor is Subhash.
So Bhaskar is Subhash's son.
Yes.
Bhaskar is the
son.
Yes. Very.
His case of reasonable requirement, he is a doctor, my lord, he is going to retire, and his daughter is also, my lord, studying, pursuing her studies, my lord, in England. My lord, he is also pursuing, my lord, the MBBS course. And
his
so
family would comprise of daughter and him.
Daughter, him, and his wife.
So 3 rooms is reasonable.
No, they have already got 2 rooms. The 3 rooms, my lord, another, my lord, that is their reasonable requirement.
3 other. 5
other.
yes.
Now, my lord, what happened, my lord?
Daughter is pursuing her studies there.
Yes, as per plaint. But, my lord, admittedly, my lord, the trial court found, my lord, that no document with regard to the study of the medical, my lord, course, my lord, before the, my lord, England is being, my lord, filed or produced. So, my lord, his requirement is also not based on, my lord, any.
Her studies are not material.
No, not
as a
material,
daughter, that
because
is material.
it
If
is
she
not
does
for
not
the
study, she
residence
requires a room
purpose.
to stay all the day.
Yes, for blood, it's not for chamber also.
No,
it's not for chamber. It's only for residence.
Husband, wife, one
Yes.
room, daughter, one room. 3 other must be drawing, dining, the usual things.
Blood, yes, one maid servant and all that, blood, that has been pleaded.
What is the age of this Dr. Sen?
Dr. Sen,
approximate age?
Milord, in
70s.
Now he, Milord, alleged to have, Milord, retired sometime in the year 2010. Milord, he wants to come back. Milord, that is his case. Now,
What
Milord,
is the second ground?
yes, second
You have
ground
started with Subhas but not ended in you.
No, Milord, that's right. Milord, the 4 sons, ultimately, Milord, the partition deed was executed, and the demarcation 3rd floor of the suit property consisting of 5 rooms, 1 balcony, covered passage, along with 2 bath and privy was allotted to Subhash, over which, Milord, 2 of the rooms he got, Milord, possession in respect of a eviction suit. Now, Milord, the one of the unmarried brother, he died, bachelor.
Milord, your lordship, Milord, I have shown before your lordship that it's kind of a flat system. A building, Milord, consisting of several floors. Floors are being divided in respect of
Total
the,
how many floors?
Total, Milord, four floors.
Mother is alive. Kollani?
No.
So 4 get for each one each.
No, not that. Milord, that one unmarried, because mother, Milord, the life interest was there, Milord, thereafter, Milord, it goes.
Yes, yes.
So, Milord, thereafter, the in respect of this, Milord, one unmarried brother, Milord, interest has been, Milord, inherited by the other, Milord, remaining brother in respect of ground floor and fourth floor. So, Milord, the plaintiff, during pendency of the suit, or rather prior to the suit, when the bachelor brother died, have got, Milord, interest in respect of the property in the ground floor as well as fourth floor. There is a specific, Milord, contention raised in before the trial court as well as the appellate court that the plaintiff consciously has not, Milord, made inspection in respect of those two floors. That has been negated, Milord, with a view, Milord, your lordship knows, Milord, that is one of the view of the Honorable Apex Court, that if a fractional share I do have in respect of an undivided property, that can be negated. But here, that is not a case. It is in respect of the same building. It's not that, Milord, I am acquiring...
It's a fractional share after all. It does not translate into a suitable alternative accommodation.
But, Milord, if it is a floor in some portion in the ground and fourth floor,
there's a title there, joint,
same building.
Joint title, Milord, every inch, every co-sharer has a right.
I agree, but, Milord, if it is a flat system, there are several rooms in respect of that flat. Like, Milord, in the third floor, the plaintiff do have 5 rooms. So, if that be so, in the ground and fourth, there are suite rooms, not suite room, non-suite rooms.
One of the plausible views. That is the test in second appeal. It's not a perversity. It's one of the plausible views. Preponderance of probability and plausible view are very risky factors for an appellant in a second appeal.
That is, Milord, that
because our scope is very, very limited. Even if this was the first appeal, in any event, we had to go into
this. Yes.
But even then, it's a plausible view, not one to be discarded outright from the, at the outset. These are the 2 points.
Yes, these are the 2, Milord, I must be. And the other points, Milord, regarding the suite rooms, Milord, I must be, Milord, that is one of the view that has been taken by the first appellate court, that even if, Milord, one of the kitchen has not been described, Milord, that cannot be a ground for, Milord, dismissing the suit altogether. But these 2, Milord, primarily, Milord, this, Milord, whether, Milord, the concept with regard to the fractional share in respect of an undivided dwelling house, wherefrom, Milord, I do have my separate accommodation, but that is tenanted, Milord. Nevertheless, Milord, yes, the court can negate. But if it is in respect of the same building, and, Milord, the other brother and the sisters, they are there. Aunt is, Milord, on behalf of me, Milord, on behalf of the plaintiff is filing the suit. So it's not that, Milord, they have acrimony.
How was it dealt with by the appellate regarding the joint share?
Yes.
And say section 2, what about Power of Attorney Act? What was held there?
Yes, both these 2 findings, Milord, may I just take your lordship to that? If your lordship takes up the trial court judgment once.
Yes. Trial court first.
Trial court first, Milord, if your lordship takes up.
No, it's not there. We don't find the trial court at all.
Milord, the trial court judgment is the...
File later? Or, yes,
the first is the appellate court, Milord. Milord, it's 144, SAT 144.
Probably file later.
Oh.
Anyway, no difficulty. Which page?
Milord, page 13. Internal page 13.
Trial court? No, এটা appeal court. একটা কপি থাকবে। দেখুন একটা কপি আছে, এরকম আলাদা করে ফাইল হচ্ছে। ওটা ওটাতে appeal court। তার কাছে কোনো কপি নেই? Yes. Sorry, please continue. 13, page 13.
Milord, prior to that, if your lordship takes up page 3 once, because your lordship kindly takes up the 5th paragraph,
yes,
last 2 line, Milord, or rather the 5th paragraph. It is the positive case of the plaintiff that presently he resides at such and such, yet called Liverpool, in connection with his service. It is also been mentioned that the affairs of the suit property are at present looked after by the aunt of Purnima Sengupta, who in the capacity of the constituted attorney had also instituted this suit by putting her signature on the plaint. So it's my lord on the behalf of the lord appointer, my lord, he is acting, my lord, on the basis of the power of attorney. Now, if your lordship takes up, my lord, page 13, issue number 6 and 7. The bone contention between the parties have boils down to the present issue, whether or not the plaintiff reasonably requires the suit premises for use and occupation of himself and his family. The defendant disputed the said ground on various points. Firstly, the authority of the PW1 to institute the suit and depose on behalf of the plaintiff had been agitated. The power of attorney marked as Exhibit 1 in this case, on the basis of which the PW1 performed the said acts, had been challenged on the ground that it does not bear the signature of PW1. That is, my lord, the aunt. Secondly, it has been contended on behalf of the defendant that the PW1, being the constituted attorney of the plaintiff, is not in a position to state about the mental condition of the plaintiff regarding the willingness and desire of himself and his family member to return to India. This, my lord, I must be candid, because, my lord, the plaintiff's own wife also deposes as one of the witness. So, my lord, I cannot take that sole, my lord, PW1 being the constituted attorney, how she can adduce evidence. So that has been negated. If your lordship turns over the page, this portion I have shown, this has been agitated, the non-signature. And now, my lord, page 14, first paragraph. It has also been submitted on behalf of the defendant that the plaintiff suppressed his present accommodation. His learned advocate emphasizes that the plaintiff has his own share in the ground floor of the suit building and also inherited an undivided share on the 4th floor thereof after the demise of his uncle, Prabhas Sen, who admittedly died bachelor, issueless, and intestate. It has been stressed that these portions have not been inspected at the instance of the plaintiff, which tantamounts to material suppression of fact, resulting to the disentitlement of the plaintiff to get the decree as prayed for. Now, my lord, if your lordship takes up how this has been dealt with. Now, my lord,
He did not specifically rely on section 2.
No, not
technicality, held to be a
yes,
technicality.
page 131, if your lordship takes up
Technicality.
last paragraph.
Technicality.
Signature of the, yes.
Merely a technicality, and
yes,
execution has not been challenged.
Now, my lord, the accommodation part, if your lordship takes
Yes.
up, my lord, coming, my lord, the page 132, second paragraph. Coming to the accommodation available to the suit property itself, it has been admitted in course of argument that the 2 rooms occupied erstwhile tenant Arun Malhotra had been surrendered, and the plaintiff is presently possessing the same. From the partition deed marked as Exhibit 6, read with rectification deed Exhibit 7, it is evident that the different floors of the suit building has been allotted to the different co-sharers, and the plaintiff clearly has no right in the first and second floor of the suit property. It is undisputed position that he has some interest in the ground floor, which has not been partitioned by meets and bounds and kept as joint property. It is also an admitted fact that the plaintiff has earned some interest in the 4th floor of the property after the demise of his unmarried uncle, but the share of the plaintiff in the ground and the 4th floor are undivided, and there is no exclusivity of possession, ownership or possession in respect of the said portion. Now, my lord, the judgment which has been, my lord, relied upon is with respect to those lines, my lord, where, my lord, I do have a separate accommodation which is joint in nature, where I do have a fractional share, but not in respect of the same building. That is, my lord.
Alternative accommodation all the same.
Yes, but if
same building was not the deciding factor there. The deciding factor in the ratio of the judgment was that fractional share is not sufficient, not exclusive. I having a fractional share, I mean,
this point, my lord, has in the same tune has been dealt with by the appellate court.
Sorry, Mr. Mukherjee. Thank you for the fair submission, but sorry. The present challenge has been preferred. Sorry. The present second appeal has been preferred against a judgment of reversal, full stop, whereas the learned trial judge dismissed the eviction suit of the plaintiff respondent primarily on the ground that there was a misdescription of the property insofar as the number of rooms in occupation of the landlord being described as 3, whereas the same ought to have been stated to be 4, comma, the appellate court reversed the same on the ground that the minuscule kitchen in occupation of the landlord cannot translate into a separate room, and comma as such, comma, the description of the number of rooms was justified. Full stop. The however, comma, next para, however, comma, both the courts below returned concurrent findings as to the plaintiff respondent having reasonable requirement in respect of the suit property, and comma as such, comma, substantially the present challenge is against a concurrent finding of both the courts below on the relevant factum of the plaintiff having reasonable requirement for the suit premises. For some next para, learned counsel for the defendant appellant primarily lays stress on two grounds. First, comma, the suit was instituted and conducted by the aunt of the plaintiff on the strength of a power of attorney executed in her favor, comma, which document was also exhibited in the suit, comma, which was not signed by the constituted attorney, comma, although signed by the author of the power of attorney. For sub next para, it is contended that there is a it is contended that section 2 of the powers of attorney or power of attorney powers of attorney act mandates that both the appointer and the appointee have to, that is the language used, Mr. Mukherjee.
Yes.
Appointer and the appointee have to sign the power of attorney for it to be valid. For sub next para, it is next argued that the admitted position is that the plaintiff all inherited a share on the ground floor and the fourth floor of the premises, comma, whereas of the suit premises on the demise of one of the uncles of the plaintiff, comma, who was also a co-sharer. Full stop. It is contended that since the fourth and the ground floors were not disclosed and or no local inspection was held to show the accommodation of the plaintiff on such floors, comma, the suit ought to have been dismissed. Full stop. Next para. However, comma, we cannot agree with the contentions of the appellant on both the above counts. Full stop. Next para. Insofar as the effect of section 2 of the powers of attorney act is concerned, comma, we find that the same is not mandatory but directory from its very tenor. Full stop. Next para. In the facts of the present case, comma, we find that the power of attorney was duly signed by the appointer, comma, that is the plaintiff himself, and was acted upon to the hilt by the constituted attorney, comma, who filed the suit and conducted the suit, as well as adduced evidence as one of the witnesses of the plaintiff in the suit, comma, thereby squarely acting on the power of attorney. Full stop. As such, comma, since the power of attorney was acted upon and there was no challenge to the same from the quarter of the appointee, comma, we do not find the non-signing of the power of attorney by the constituted attorney to be an impediment to deter the court from passing a decree in the suit. Full stop. We find from the findings of the court below that the courts below proceeded on the premise that such non-signature was a mere technicality with which we are ad idem. Full stop. Next para. Insofar as the second ground is concerned, comma, the appellate court placed reliance on a judgment of the Supreme Court reported at 2001 9 SCC 692, where it was held that the existence of fractional undivided share in a building under the occupation of the landlord is not a bar to his plea of reasonable requirement. Full stop. Learned counsel for the appellant seeks to distinguish the said judgments by trying to impress upon us that the same was rendered in the context of an accommodation available in a different premises, whereas the alternative accommodation here is in respect of the same property. Full stop. Next para. However, comma, whether whether the alternative accommodation was situated in the same property or in a different property was not one of the yardsticks of the ratio as laid down in the said report. Full stop. Moreover, comma, the courts below correctly proceeded on the premise that the existence of a share existence of an undivided share of the plaintiff in a different portion of the property cannot translate into exclusive possession of such share by the plaintiff. Full stop. As such, comma, we cannot come to the conclusion that such availability of undivided share itself tantamounts to suitable alternative accommodation to deny the plaintiff the relief of eviction on the ground of reasonable requirement. Full stop. Next para. In view of the above discussions, comma, we find that there is no scope of interference with the concurrent findings of the courts below, comma, since there is no perversity, comma, nor is any substantial question of law involved in the matter. Full stop. Accordingly, SAT 144 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed without an order as to cost.
Next is for cross appeal, my lord, 145, SAT 145.
আচ্ছা এটা এই দুটো একসঙ্গে একটা ইয়ে করে দিও উপরে হ্যাঁ করে দিয়ে cross appeal was against
My lord, since the reasonable requirement was being decided, my lord, in favor of the plaintiff by the trial judge, so there is a cross appeal, my lord. In regular appeal is filed by the my lord, plaintiff since his suit dismissed.
In view cross appealটা নাম্বার দিয়ে দ্বিতীয় appealটা নাম্বার দিয়ে in view of the above discussion, comma, since the self-same issues are involved in both the appeals, comma, we dismiss SAT দ্বিতীয় নাম্বারটা under Order 41 Rule 11 of the Code of Civil Procedure as well. Can Otter connection Can 2 of 2025. Can 2 of 2025 is also dismissed consequentially.
But Can 1, my lord, was for condonation of delay, which was allowed.
Only Can 2 was subsistent. তাহলে ওই দ্বিতীয় লাস্ট যেটা বললাম সেটা কেটে দাও, লাস্ট লাইনটা কেটে দাও, আর উপরে যেখানে Can 1টা বলেছি কনসিকুয়েন্সিয়াল ডিসমিস, ওখানে Can 2 কনসিকুয়েন্সিয়াল ডিসমিস।
Can Act of 24 Can Act of 25
check up
very well, হ্যাঁ
she's right. তাহলে যা বলেছিলাম তাই থাকবে, কাটাকুটি গুলো হবে না। Can 1 Can 2 দুটোই। থ্যাংক ইউ, আপনাকে থ্যাংক ইউ অ্যাকচুয়ালি। নেক্সট করুন। Yes.
Under the supplementary affidavit with the explanation details, copy has been served.
That
Paragraph 4.
That section 5 where no explanation was given. Yes, you should pay us fees for that. But what is the explanation now given?
Medical ground. The paragraph 4.
What is the length of the delay?
625 days. 625. That is as per the report.
What is the medical ground?
For medical ground, I have annexed all the documents.
What is the ailment?
The certificate has been issued by the
By?
medical doctor. The page, annex page 5, annex P2.
Is he a doctor actually?
Yes.
This is his government registration number. What is government registration number?
He is a doctor also.
Dermatologist. অভিজ্ঞ প্রাক্তন মিলিটারি ডাক্তার, আর্মি মেডিকেল কোর্স।
Everything is hospitals. And apart from that, my last portion, my lord, the
এমবিবিএস ফিস কোথাও লেখা নেই, এখানে ডার্মাটোলজি স্পেশালিস্ট।
last portion, my lord, they have annexed the document.
Yes, last portion.
But the last portion after the receiving the order, certified copy,
Yes.
he was also, my lord, the asthmatic patient, my lord, I annexed the document in the original.
Asthma, how can it prevent you for not from preferring an appeal for 625 days?
That is the last portion. That is the main application in the condemnation.
The ground remains the same. In the section 5 also you stated about asthma. Medical ground is asthma.
Earlier application, my lord, this explanation was not done, but in the supplementary affidavit, I annexed the documents along with the explanation.
Earlier application, your explanation was there.
Only
You
medical-
said that you are an asthmatic patient who frequently suffers from asthmatic attack.
That is, my lord, not all the documents was placed.
Prescription was also given.
All the documents, not all the prescriptions. That portion, my
A
lord.
prescription of a different doctor was given.
Yes. Yes. That I am stated in paragraph 4, I have stated.
Of 25/1/2024.
Yes. In the supplementary
It was treated by several doctors.
Several doctors.
What have you added in the supplementary evidence? Another prescription only has been given. Another 2 prescriptions. 3.
Another earlier treatment, which has been was not annexed in the earlier petition.
Was he hospitalized ever?
No.
Asthma, many people have asthma.
Hospitalized. Not hospitalized. This is a hospital doctor, this is hospitalized.
No, no. Yeah. DHMS. সেটা কি homeopathy?
This earlier application, my lord, some portion, my lord, the medical treatment was annexed, but all the medical document was not annexed. That I am stated in paragraph 4 of supplementary affidavit.
You have also added amoebic dysentery in one of the prescriptions.
Yes.
We will be having amoebic dysentery after going through. Breathing problem, X-ray of chest. This is the first prescription. The second, no, sorry. Let us not discuss his plight threadbare, but
Second chapter, my lord, the another doctor. That is another. That is a main application condonation.
no, sorry. The delay in preferring the appeal is of about 625 days. Full stop. A supplementary affidavit filed today be kept on record upon leave being granted to the appellant to file the same. Full stop. Next para. In the original application, comma, certain medical certificates by one Dr. B.C. Mukherjee, comma, DHMS within bracket col and IAMS within bracket BIAM within bracket was furnished, indicating merely that the petitioner had breathing problems from time to time. Full stop. Next para. In the supplementary affidavit, the prescription of a different alleged medical practitioner being one Dr. S.D. Saha, comma, AMC within bracket retired, comma, government registration number 2305 has been annexed. Full stop. The said documents merely go on to show that the appellant stroke petitioner suffered from asthma and amoebic dysentery from time to time. Full stop. However, comma, the huge delay of 625 days has not at all been explained, comma, since there is nothing on record to show such serious ailment of the appellant which made it impossible for him to contact his advocate over the prolonged period of 625 days. Full stop. Next para. Accordingly, comma, we are not satisfied as to the sufficiency of the reasons for the delay in preferring the long delay in preferring the appeal. Full stop. Accordingly, comma, even taking a liberal approach, comma, we cannot extend the benefit of doubt to the appellant to such an extent that the provisions of the Limitation Act would be rendered nugatory. Full stop. Next para. Moreover, comma, the grounds taken in the application for condonation of delay do not appear to be bona fide from the very nature of the ailments pleaded. Full stop. We also have to keep in mind that that valuable rights have accrued in favor of the respondent in the meantime. Full stop. Keeping on balance all the above considerations, comma, we are not inclined to condone the delay in preferring the appeal. Accordingly, can 1 of 2025 is dismissed on contest without any orders to costs. Full stop. Next para. Accordingly, SAT 193 of 2024 stands dismissed as time barred. Full stop. Can 2 of 2025 is also dismissed consequentially. No orders to cost. Sorry. Yes. Yes, so what is the matter?
But the landlord filed a suit against the tenant.
Right?
It was dismissed.
There are certain defects. Let us just check up what are the defects.
Section 14, I had filed a civil revision. I had filed a civil revision earlier. The learned judge felt that the appealable orders to go over appeal.
Acha.
Kindly see Justice. I filed a section 14. Can you see section page 17?
Mr. Mitra, then a copy of this has to be served on the other side first. Section 5 or 14, whatever it is.
But I do not know, but this is between the court and the person.
No, but their rights have accrued in the meantime,
No,
even if
rights
it's section 5.
There, I've annexed the tenancy agreement. Not section 116, your lordship knows. Estoppel doesn't operate. Tenant
No, even
cannot
then that
enter the premises as a tenant, and then when he doesn't fail to pay, then
that's on the merits of the appeal, Mr. Mitra. But
I'm not on the merits.
section 5 we have to give up.
See, what I have done. There was an application under my title appeal was dismissed for default, non-appearing, because the managing director had died.
Yes.
You want to do Tobdi. Lower court, unless you do Tobdi, your matter is never taken up. Managing director died. Special officer filed an application. Anjuna Go, special officer. She was appointed because there was some family disputes, and she was appointed to collect the rent. So she was told, Justice Indira Banerjee appointed her, the High Court in a 397 petition. So she went one day to the factory to find out who are the tenants who are defaulters, because the order was you will collect the rent from the tenants and deposit in a separate account. So, my lord, she went to inquire when she was told by one of the tenants that, look, I've got a decree from a court saying that I don't have to pay rent. You're not the landlord. So then she said, okay, you give me the order from the court. I annexed all that. Give me the order from the court which says that you don't have to pay rent because I'm not the landlord. He could not give it. Then, my lord, she asked for the orders. Orders did not come. Then she approached a lawyer in Barasat court to dig up. My lord, your lordship knows how difficult it is. Special officer is not the party. He's just been appointed to collect rent. But she goes and finds out a lawyer, pays out of the rental income, which is depleting because the cat is away, the mice are free to play, as they say.
Mr. Mitra, serve a copy of the section 5 at least income.
Not section 5, 14. Can you see?
14 can be invoked, but
14 can be invoked. We don't have to hear.
no.
Millard, kindly see the
No, your valuable rights have accrued in their favor in the meantime.
Kindly see, Millard, the order at page 71. Millard, this was an appealable order. Learned judge says, the contention, Mr. Mitra Learned, the period limitation was.
No, that you have seen, Justice Shorkar's order probably.
Okay.
That it is an appealable.
40. Order 43, Millard, dismissal of my appeal.
Yes, it's appealable, definitely.
My appeal from the order of dismissal of my suit was dismissed for default.
Mr. Mitra, why should we construe, because a senior like you are advising them, why should you construe this to be a bona fide mistake, bona fide proceeding in wrong forum?
I was not advising. I only came into the stage of civil revision.
Then whether it's bona fide or not, we have to look into that. Because whether it's a bona fide error, revision is not an alternative remedy, because appeal is clearly provided.
I overlooked. I take the blame.
Serve a copy and come. Then rights will be taken away.
To err is human. To err is human.
Let us serve by directing copies to be served.
No. Kindly, Millard, just see this.
So, Mr. Mitra, you have to serve a copy.
See order 41, rule 17. Just give me 2 minutes time.
Absolutely, yes.
Your lordship will pass your lordship's order. I will not.
No, definitely. You are in.
Just give me some time, Millard. Order
Yes.
41, rule 17, dismissal of appeal for appellant's default. So I did not appear. My appeal was dismissed. Then, under order 41, rule 19, readmission of appeal dismissed for default.
1921.
17 and 19.
Yes.
Order 41. So, Millard, I made an application on order 41, rule 19, along with a section 5. Now, kindly see the order. Just see the order.
We cannot.
You also will not look in.
No.
At one point.
Before this
7 days delay.
section 14 or whatever.
3 months delay.
We'll look into that. The appellant shall serve a copy of Can 1 of 2024 on the respondent, indicating that the matter shall be listed under the same heading on April 28, 2025, when an affidavit of service to that effect shall be filed by the appellant. Mr. Mitra, since you are directing to serve copy, you are directing to serve lock, stock, barrel so that you can dispose of on that date. If you allow, obviously, maybe we will be allowing this. So we'll take up the memo as well as the other application also serve all. Right. That will be better for you also.
Better for me also.
Yes,
because I'm
yes.
coming time and again.
Very well. তাহলে ওই can 1 of 2024 এর সঙ্গে serve a copy of can 1 of 2024, comma can 2 of
199 of 2000.
right. Can 2 of 2024 as well as a copy of the memorandum of appeal on the respondent indicating that the matter shall be listed under the same heading on April 28, 2025 when an affidavit of service to that effect shall be filed by the appellant. Please come back, Mr. Mitra. We'll take up all the applications together.
Because once you admit you're a tenant and you sign on the tenancy.
You are lucky that they have not filed an eviction suit against you.
What?
That day is coming.
Oh, yes, yes. That day will soon come. But I will, whatever I can do, I will
Tenant
do.
may file an eviction suit against the landlord. May just think that he'll file an eviction.
Landlord has no right. You enter because of the tenant.
Now it's better for landlords also because after the 97 Act and all, it's much better.
I've got my chamber which I practiced downstairs on the 97 because after his death, 5 years, after 5 years, he said, I want to come and perform the rites of my father. My lord, I told my wife not to allow them to enter because I knew what was in the mind. But she said, no, no, let him come. It's bad in Hindu tradition. You must allow.
That's still good.
Then he filed a criminal proceeding.
Oh.
That he is not being allowed to enter the house.
Wow.
Then civil suit, injunction, restraining me from preventing him from entering the house. I left all my practice. Every day I was going to Shialda court and High Court. Eventually I succeeded after a month. Then, Millard, I made a garnishee order because of the wrongful possession. That then I had to do some payment to. Despite getting orders from the High Court, payment had to be done. Otherwise, they'll go to Supreme Court and Supreme Court.
Yes. What
will happen?
No, you never know.
Never know. I call it a special luck petition because good cases I know the Supreme Court have gone for a toss, and bad cases.
You're in a better position to say that.
Yes, and bad cases where I told the client don't go, you will be penalized. You should
Cannot
notice
predict.
you
You
should
cannot
notice
predict.
justice service.
Cannot predict anything.
Cannot predict. So, Millard, I did not want to predict. So I decided
Better to pay and
better to pay. If I can afford to pay.
Yes.
If I could afford, therefore I could pay.
Right.
People cannot afford. Now what do they do?
Absolutely.
Everyone cannot afford.
No.
And they squeeze you. They don't let you go. They squeeze you for every drop of your blood.
You seem to have had a very hard time.
Yes, Millard, I've had a hard time, but I've got my chamber back. I've set up my chamber on the ground floor.
Thankfully for your clients.
Yes, because Millard, the house was built by my grandfather.
Yes, yes, yes.
No lift in those days. The 50s, no lift. So some old people used to come to my chamber. They could not climb.
Yes, yes, definitely. There are so many people.
Nowadays, what is there? Some lawyers in Shialda court are telling me no suits are being filed. I said, why are not suits being filed? Because they're going directly to people on the streets. They tell you, Dada, apni কোর্টে গিয়ে যেটা 10 বছর হবে আমরা 1 মাসে করে দেব। And they are being evicted. And these people are getting money. That is what is happening today. And if you tell a judge that, he'll say that don't disturb us. But that is the ground reality. Why are people not filing eviction suits? Because they're getting justice on the streets from dalals. And once you pay the dalal, your tenant will get a call, your daughter is studying in that school. Okay.
Oh.
Like that. We cannot do that. We are not educated to do that. But they do it. And then they will get vacant possession for you in 1 or 2 months' time and give it to you a payment of money. And you know, if you go to a court in Barasat or Shialda local court, it will take you 10 years, if not more, to get an eviction decree. Then again, 227, how many 227s and appeals?
No one knows.
Don't know. And which judge it comes before, he can see through the thing. Because Millard, sometimes Millard, we expect the judge to see through the case and to make up his mind. Every
True.
time we cannot tell the judge this is. If the judge cannot see through and what is happening, what can we do?
Yes.
I tell my clients that. Bad luck. Times have changed, different things. The judge cannot see through your case. I'm sorry. I cannot help you. You expect at least something from that side.
Yes.
Well, I'm sorry to taken up your time.
No, not at all.
But this is extrajudicial.
Right.
Extrajudicial.
It comes from the heart. So
It comes from the heart.
Definitely.
I told one Justice Vishwanathan also that in Supreme Court. If you don't want to hear me, please shut me up. He did not shut me up. He said, no, we want to know. I said, what do you want to know? Things you already know.
You want to know from my mouth what you already know or should know.
Right.
These people take money and they evict the client, the tenant. Landlord get the promoter.
Your clerk is getting tensed. Probably you have something else somewhere else.
He will not. He gets tense for other reasons.
He knows.
Grateful to your lordship. I will
No,
serve
no, thank you very much. Yes.
Lordship, I appear for the appellants.
Yes.
I'm the defendants in a suit for specific.
There's a caveat, Mr.
There was
Devjit.
a caveat. Mr. Mukherjee was appearing all along. Even on the last occasion, he had appeared.
Have you admitted the appeal?
No, Lordship, there is no formal order of admission.
Let us
yet.
hear it on admission. Yes. He lodged a caveat or something. Oh.
There was a caveat. He was appearing all along. There was a talk of settlement. Lordship's order.
That has failed.
Start.
That has
yes,
failed.
that has failed. And Lordship, I will just invite your Lordships to the previous order dated 8th.
Talks of settlement going on.
Sorry. No, Lordship, the order previous to that, there.
Yes.
Lordship,
That's a standard's order.
yes, that's a standard's order. There was a specific instruction on my part that we are ready to register the sale deed. That was all along the stand. And they were directed to,
This is a specific performance suit.
specific performance suit.
Their
Lordship,
suit.
their suit.
So you are agreeable. So what prevented?
Lordship, he does not have the funds. There's no readiness and willingness. He cannot come up with the funds. Lord, it is a agreement for sale dated 12/12.
You are challenging the refusal of an injunction, the grant of an injunction.
An injunction, Lordship. Lordship will kindly take up my supplementary. There are 2 letters to that. Supplementary affidavit.
Difficulties, Ms. Lahiri, we cannot, if you stay the injunction order at this stage.
I understand. Lordship has to possibly hear up.
You do this. Give a notice to Mr. Mukherjee.
I will.
Give a written notice to Mr. Mukherjee. We'll take it up on Monday. Tomorrow we take up hearing matters
Monday,
first.
Lordship. I'll come back.
We'll record that he's not here and we'll record your submission that talks of settlement have failed.
It has failed. It has failed. It has.
None appears for the respondent at the time of call, although the respondent was represented through counsel on the last few occasions. Full stop. Learned counsel appearing on behalf of the appellants submits that the talks of settlement which were going on between the parties previously have failed. Full stop. Learned counsel also draws our attention to an order dated January 15, 2025, passed by a coordinate bench, where it was recorded that the appellant had taken specific instruction, the learned advocate for the appellant had taken specific instruction from her clients that they are ready and willing to sell the property by registered sale deed, provided the balance consideration money is paid by the respondents. Full stop. It is insinuated by learned counsel for the appellants today that the respondent is not capable of paying the balance consideration and as such is not ready and willing to justify the grant of specific performance. Full stop. Since the respondent is unrepresented today and we intend to take up the appeal for hearing under Order 41 Rule 11 and thereafter, depending on the outcome of the said hearing, the connected application, it would be appropriate for the ends of justice if a further notice is given to the learned advocate for the respondent. So accordingly, the learned advocate for the appellant shall give a notice to his counterpart appearing for the learned advocate on record. You are Mr. Chatterjee. Mr. Chatterjee, you are the advocate on record. Then we'll say he. That's why you are. The learned advocate on record for the appellant shall give a notice on his counterpart appearing for the respondent, indicating that the matter could not be taken up today due to the absence of the respondent and shall positively be taken up under the same heading on April 21, 2025, irrespective of the presence of the respondent.
I'm extremely.
Just give a server copy, give a server copy, put a server copy along with your
I will.
Next.
Section 5 is there, my lord.
Have to serve.
Yeah, yes, my lord.
The appellate shall serve copies of the application of Can 1 of 2024. Serve the other application and the memo also like the other. The appellant shall serve copies of Can 1 of 2024, Can 2 of 2024, and a copy of the memorandum of the appeal on the respondents indicating that the matter shall be taken up under the same heading on April 28, 2025, when an affidavit of service to that effect shall be filed by the appellant.
To appear for the appellant petitioner, my lord.
Yes.
Lord, decree of reversal. I am coming up against a decree of reversal by the learned appellate court. Lord, he is with
Caveator.
me.
Caveator with you. Same side.
He is with me. He is with me.
No caveat.
No caveat.
Yes.
There are certain defects.
Sorry, degree of reversal.
Degree of reversal.
The defects have been removed.
Defects, I believe, has been removed. Lord, the defects are first, Lord, that certificate copy of the learned trial court's order was not furnished. That has been furnished. One, Lord,
Memo
two,
you have
Lord,
corrected.
Yes, that has been, the number has also been corrected. And Lord, there are a few other defects which perhaps still remain in the body of the petition, in the body of my application. As regards to Lord, certain blanks are there. Lord, not very much, Lord,
The
very
supplementary
important.
affidavit will be required.
Lord, not very much important, Lord, missing is there. If your lordship
What are
takes
missing?
up,
Give us examples.
one name was not missing. One name was not missing. One name is missing, Lord, which is gone down as blank.
Name of?
That is all. Name of the petitioner. Name of the petitioner.
Name of the petitioner.
Name of the petitioner. That has gone down as blank. So not very substantial.
Well, let us hear you on the order for
But coming to the appeal, my lord,
reversal.
the background, the degree of reversal.
You are the
title. I am the plaintiff in the trial court and respondent in the my lord, first appellate court. Now, my lord, the suit was instituted by me for my lord, declaration of title and injunction upon the my lord, defendant there, the respondent here. Now, my lord, if I may give a short background of the matter, my lord, the property which is in question was originally, my lord, owned by one Taisuddin Sheikh, Taisuddin, and also alias as Taishuddin Sheikh. Now, my lord, after his demise, he left behind one widow by the name of Siddika Bibi, one daughter Samiran Bibi, and one son Karim Sheikh. Now, in 1955, a suit was filed for partition. The plot in question is a plot number 910 in a certain Moja, certain district. This plot comprised of 53 decimals of property. The suit of 1955 was decreed in compromise between the parties. These three successors of the original owner were parties, along with certain other parties, certain other 20 other persons who own various portions of the same plot. So they were all made parties in the partition suit. The partition suit culminated in a decree of compromise in 1956. By this decree of 1956, the widow Siddika Bibi and Samiran Bibi, the daughter, were given 14 decimals of land. Now
together.
14 decimals out of that,
Together.
Jointly.
But that was demarcated portion from the
Demarcated,
others.
that is the whole question which your lordship will be deciding. If your lordship has put this question to me, it is perhaps the only question which lies with your lordship. But I do not have the copy of the compromise decree with me. That is where I am handicapped. But if I may show to your lordship from the judgment of the learned appellate court, it says that the 14 decimals starts from the northern portion. From the north, 14 decimals. That is decided, that is been held.
That is the suit property.
That is a suit property. In the suit property of plot number 910, the 14 decimals which was decreed in my favor is held to be given from north. And the learned judge, while saying so, was quoting paragraph 5 of the Solenama decree, of the Solenama, of the compromise petition. If I may invite your lordship's kind notice.
You sought your declaration. You are
I am seeking declaration.
The widow and the daughter.
No, from there I have the property has come down to me through my lord gifts and through my lord succession. I am finally owning the property after one succession and gaining the property from the ultimate owner of the property, from the ultimate owner of the
from the heirs of widow.
From the heirs of from the heirs of the widow and the daughter.
But you have purchased demarcated portion and now you seek exclusive title, declaration exclusive.
Yes, my lord, I am my lord, the declaration is for my lord to restrain them, the injunction to restrain the defendant from getting into my property. The defendant has also purchased the property from the original, from the son who my lord succeeded to the estate.
How did the appeal court go about it?
If your lordship kindly comes, my lord, to page, my lord, the reasoning portion starts, my lord, from page 52. Before that, the issues are framed and my lord, the facts are set out. And if I may invite your lordship's kind notice.
You have not annexed the original certificate copy? Oh, yes, it is.
The certificate copy is there with the.
Yes, yes. এটা তো স্ট্যাম্পটা অরিজিনাল আপনার কাছে অরিজিনালটা আছে মেমোতে ও এটা সরি না এটার সঙ্গে অরিজিনাল প্রথমে ফাইল করেনি বোধহয়
I'm sorry.
It's so short.
The judgment is about, my lord, the appellate decree and judgment is about, my lord,
Oh, it's an
15
ex parte
pages.
judgment.
14 pages, no? my
No,
lord,
this
it
is
was
delivery of judgment. Where is the original judgment?
Okay.
You have annexed only this ordering portion.
Ordering portion of this question should be
Where is the 14-page judgment? It's not there in the memorandum.
in the memo of appeal, your lordship is looking at the memo.
No, memorandum of appeal is with us. This is the only thing which is with the memorandum.
Judgment appeal.
2-page ordering portion it's defected any memo. Certified copy of the judge.
Judgment appeal.
এটাই তো দেয়নি কি আশ্চর্য ওটা তো জেরক্স কপি সার্টিফাইড কপি অফ জাজমেন্ট দিতে হয়েছে
I'm so, my lord, apologetic, my lord.
the appeal is in time but by so many days or years maybe no not years the entire judgment yes
The
revised report certified years seram dekhe naini
Lord, 12th of December 2024 is the date of delivery of judgment.
you can check up I mean this is only the only thing this is
I'll
the
have to
memorandum
provide then. I'll have to provide, my lord. I'm so very apologetic.
and
my
the
lord.
judgment of suit has been subsequently certified copy has been given
I understand, my lord.
no you have to file the entire judgment otherwise how can you pass
Lord,
we
I can
find
also-
from the records that the entire judgment of the appellate court has not been given but only the ordering portion thereof and the decree of the appellate court. First of next para, accordingly, the appellant is directed to file the entire certified copy of the judgment of the appellate court as well as the second judge's copy thereof within a fortnight. Do it within a fortnight. Within a fortnight from date. First of the matter shall next be listed on April 30, 2025 under the same heading.
My apologies, my lord.
No, it's okay, but you file it and they will proceed on that premise.
So very grateful, my lord. So very grateful.
You are also probably not aware.
I was not aware, my lord.
You can check up later on the records if
check
you
up,
want.
I'll check up.
If
Sorry,
you are
sir.
missing out something. Yes, who is appearing 49?
I'm for the appellate.
Yes.
Subsequently, take up this matter next week, my lord.
Why?
It's Section 5.
You haven't filed section 5?
No, 2 days delay. Maybe
But
one
here
day
you
or
have to
2 days.
file formal section. On the prayer of the appellant, let the matter stand adjourned till when?
My lord, next Wednesday.
Till April 23, 2025. Full stop. Leave is granted to the appellants to file an application for condonation of delay in the meantime and to mention the same for enlistment along with the appeal.
My lord, let this matter appear, my lord, on that day.
Yes, you have directed it to appear on 23rd.
Yes.
Adjourned till 23rd April. You have been given liberty to file application and mention it for inclusion in the list.
In the meantime, my lord.
In the meantime.
Great.
I'm for the respondent number 1.
Yes, sir. What is the matter?
But there is a defect, my lord.
You are for both sides. It's a collusive matter.
No.
Yes, both are of my bar. Definitely collusive. Prove the onus is on you to prove it's not collusive.
Because
Why? What is the defect? What is the defect? You are the appellant.
Valuation, my lord. There is 2 shoot, my lord.
Bereft of valuation statement. You have to give a valuation statement.
Valuation there during pendency of partition shoot, my lord, partition shoot valuation, my lord, different and declaration.
What is the valuation of the suit? Is it maintainable before this court?
My lord, page 10.
FMET letter C, civil judge senior division, yes.
One civil judge senior division, other civil judge junior.
Memorandum of appeal also आगे देखिए where is the plaint?
Page 10, man. Page 10, this is the declaration shoot.
देखो page 10 evaluation.
And page 20, this is the partition shoot, my lord. During pendency of the partition shoot, they obtained order of injunction.
Not maintainable before this court.
Page 10, my lord. This is the
It
partition.
was collusive after all. It's not maintainable before this court. But Mr. Pottu, we have to keep a copy of the plaint on record. Have you got an extra copy? Because we have, on the basis of that we have to pass this challenge. Can we keep that on record? Very good. On query of court, a copy of the complete plaint is handed over by learned counsel for the defendants respondents. First of we find therefrom that the valuation of the suit is rupees 400, comma being rupees 300 for declaration and rupees 100 for injunction. Accordingly, the appeal is not maintainable before this court due to lack of pecuniary jurisdiction. Accordingly, FMAT 112 of 2025 is dismissed as not maintainable due to lack of pecuniary jurisdiction, with liberty to the appellant to prefer an appeal before the appropriate court having pecuniary jurisdiction. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing a duly approved photocopy of the same for the records. Can 1 of 2025 is dismissed consequentially without any orders to cost. The copy of the plaint handed over in court today be kept on record. You this will go down to the department. You just take back the certified copy upon furnishing.
Initially, revision was filed challenging the order. Thereafter, this.
Initial final revision.
So why so many mistakes? You should know. You are doing this better similar. Whenever you're in difficulty, just contact Mr. Parthrapratim Rai. He loves to be appointed as amicus curiae. That's why he's jutting out his face between you two. Yes, next matter. Whatever is there to do gratis, Mr. Roy will appoint you as amicus curiae. In the first case, you, the next case, Mr. Shonak Bhattacharya, and whoever is laughing. By turns. Yes.
This is dejection for service of notice.
This is item 51.
51, my lord.
Miss Appeal, this is maintainable here.
Yes, my lord.
Against what? Injunction grant or refusal?
Injunction, my lord. Granting of order injunction.
It was admitted previously. Why affidavit of service?
Because earlier bench, my lord, there is direction. My lord, don't put this question. We are facing difficulties, my lord.
Justice Tandon is to direct.
His lordship was of the opinion, I'll decide the matter. Order 41 stage injunction. So,
yes,
but it will be hard.
We will deem this to be
at that point of time, my lord,
normally admitting it, and you have served, they have received.
Yes. Because at that point of time, my lord, Justice Tandon has only the order 41 determination. Hearing lies before my lord, this honorable court. So his lordship, once I admit
that was the right approach because it would save trouble to the getting it admitted
yes,
there.
Then it will transfer.
But wouldn't it be better if you admitted and then the same thing? We find from the order dated November 6, 2024 that copies of the connected application were directed to be served on the respondents. Full stop. In any event, since the appeal has been preferred against what? Grant of injunction?
Yes.
Against an order granting temporary injunction, questions of both facts and law are involved, and as such, we deem the appeal to have been admitted for all practical purposes by the order dated November 6, 2024. First up, we find from the affidavit of service that due service has been effected on all the respondents, Mr. Rai.
May I check? May I check?
Check up.
Yes. Service not been affected.
That due service has not been affected on all the respondents. Full stop. Mr. Rai, there is no scope of stay.
No,
so we'll direct you to prepare informal paperbooks and direct the appeal and the application to be heard together.
Yes, my lord.
Lower court will try.
Prepare the only informal paper book?
Yes, informal papers. So next para, accordingly, the appellants shall serve fresh notice on the unserved respondents. Please check up who are not served.
I'll serve all the because all
fresh copies of the application as well as the memorandum of appeal on all the respondents.
Plenty respondent, my lord. I have the defendants, my lord.
Very well. Shall serve copies of the application as well as the memorandum of appeal on the plaintiff respondent numbers 1 to 6, indicating that the appeal and the application shall be taken up together for hearing on May 13, 2025 when the matter shall be listed under the same heading, full stop, the appellants shall file an affidavit of service to that effect on the next returnable date. Full stop, service on the
Other pro forma respondent, defendant
Yes.
pro forma respondent.
on the pro forma respondent numbers 7 to 16 is dispensed with. Full stop, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records in the meantime. Full stop, the notice served by the appellants on the respondents as directed above shall be deemed to be notice of the appeal as well. Full stop, the in view of the short scope of the appeal, the trial court records need not be called for. This much.
Along with the copy of this order, I'll submit. Generally, it will be. Along with
Yes,
the copy,
along with a copy of this
because
order.
your lordship was pleased to hold that the notice of appeal will be
Right. যেখানে বলেছি যে copies of the application can such and such along with a copy of the memorandum for appeal as well as a server copy of this order.
Yes, Honorable.
You're right. Thank you. মানে সার্ভ করবে আর কি as well as a server copy of this order.
Grateful to your lordship.
Thank you. Yes.
Madam, Mr. Mukherjee is appearing.
Which Mr. Mukherjee?
Gopal Mukherjee, my lord. And he's
You are
out,
there.
He's out of station. My lord. Kindly take him next week. My lord. Next
Well, থাকবে ছুটি. Monday? Yes, Mr. Mukherjee is not there. Within the country or outside?
Oh, within the country.
Then we will not adjourn. On the prayer of the appellant, appellants let the matter stand adjourned till 21st. Till April 21, 2025. Give your names, yours. Yes.
I am being laid on Mr. Shoptangshu Basu, senior counsel. Today she is not present. He is not present.
How long are you practicing, ma'am? How long are you practicing?
Not 3 years.
3 years. What is the matter about?
But this is a appeal for, against the refusal of the ad interim injunction. And the
Refusal of
suit
ad
is for
interim
the
injunction.
cancellation.
The suit is for?
Cancellation of the deed.
Why was it refused? Have you got a copy of the brief?
I am paying for notice week.
You are Ms. Kulovi?
Yes.
Ms. Kulovi, learned counsel appearing for the appellants, starts the matter. Full stop, however, comma, at this juncture, comma, in view of the absence of the learned senior advocate representing the appellants, comma, an adjournment is sought. Full stop, accordingly, let the matter stand adjourned till April 21, 2025. It's good to see your name on print. Yes, next. এটা ভালো লাগে নিজের নামটা আমার জজ সাহেবরা আমার রেকর্ড করে আমার খুব ভালো লাগে ম্যাটারটা জানে মানে ইজ এন্টাইটেলড ম্যাটার জানে মানে অধিকার আছে নাম থাকার অর্ডার yes 54 who is there none sure none appears for the parties let the matter stand adjourned for the day where is Mr. Mondal yes oh Mr. Bhattacharya is also there. You choose your juniors, they're your namesakes.
Can it be taken up on 24th?
Why? You are
Mr.
practicing for more than 3 years, Mr. Bhattacharya.
Mr. Chatterjee is leading. He is not.
Mr.
Chatterjee, Aniruddha Chatterjee.
When is he expected to
He will be there, Milord.
make his appearance before the court?
Milord, he is not there for 2 days. Now, Milord, problem is, Milord, I will be not there on Monday, Tuesday, and Wednesday. Due to
Then you move the matter right now. What is the matter about?
Milord, this is a
You will not be there till when?
Milord, till I will be there. Come back on 23rd.
24th, 20th. We are keeping it on 28th then. 24th we will be taking up appeal. On the prayer of the appellant, let the matter stand.
29th.
On the prayer of the appellant, let the matter stand adjourned till April 29, 2025.
Grateful, Milord.
Thank you. Next. Yes, Mr. Mitra. You are for the respondent.
I am
Should be admitted on that ground.
my learned friend for the other side.
So
I am paying Miller only days accommodation because I am confusing.
this is bad, Mr. Mitchell. You are
I have
intimidating your.
Miller. In fact, I
And
could not
since
go.
Mr. Rai, you are leading Mr. Rai, there is nothing in your case.
Miller, I am
Need not be, don't need much preparation. What is the matter about?
against the injunction order. I have come. Lord, I have not yet be prepared myself. It is my fault, Miller.
Lord, only thing.
Miller, only not.
I'm not
No, no, no.
signing in- I'm
Well,
not
let's
Very well,
do
we'll
one.
grant. Let us say yes.
signing in the way. This stay petition, my lord, does not include the on the basis of a direction given by this honorable court by Lord, another division bench. They were supposed to file the affidavit in opposition within or written objection within a particular time. That was not done. The application, the court said, the division bench said that the application shall be heard by this date. Application was heard and my lord, injunction application was my lord passed.
Without the objection, because they did not file with it.
No objection was filed. In fact, possibly, my lord, they did not appear on that day.
Even without taking into account the maintenance of this.
That he will be taking that point that had to be considered.
Now,
Well,
today,
some-
my-
well, anyhow, Miller, I don't
না,
like to.
এক minute, আমি কিচ্ছু বলছি না। The ballot stay petition ballot does not even include ballot the injunction application. Forgetting about the plate. না, নেই।
Injunction application আছে, sir.
আছে?
হ্যাঁ,
Which page?
I have.
In that event, I missed.
It's not there probably, Mr.
I believe, Miller, it has been annexed. In the memo, it is there.
I tried to check it.
In the memo, it has been annexed.
Memo,
Deed of sale they should-
memo could not be annexed.
Deed of sale.
How could the injunction be annexed to the memo, Mr.?
Yes, I have annexed.
To the memo, injunction application has been annexed.
No, impure order, injunction
Not say,
application has
speaking
not
about
been
the impure order,
annexed. No,
Mr.
injunction application has not been annexed.
The plain
Injun-
injunction
No,
application
I
have
have-
to be
I
annexed.
have-
What will you know on the basis of what it has been passed?
I have not annexed. It is a bulky one, big volume. So I have not annexed. It is to be prepared in 2-3 volumes. But it is a big one, about 500 pages.
That's
So I
sufficient-
did not, but I
sufficient-
gave to defer at the time of the hearing, Milord. I believe, Milord.
When do you want to come back?
I like to. come
Whenever
back
you
on
like,
Monday.
we'll put them at.
Monday. Milord,
They'll have to make time for it.
Milord, I will not be available on tomorrow also.
Whenever you say, we'll keep
Milord,
it. And
one
Mr.
month
Mitra and
I-
Mr. I have to be there.
Only today and tomorrow.
You're keeping it day after tomorrow?
Your Lordship knows I never pays for that.
No, you don't.
For my
Generally, don't. So you're keeping it on 21st, Mr. Mitra?
I shall make my submission, sir. Because the documents here in this stay petition were not before the court.
What is this?
That
No,
might,
no,
that
no,
might
no,
be my.
Documents which are
That
there,
might be,
the basis of the order are not here.
No,
And the documents which have been annexed were not produced before the court below. How can you look into that?
I can't answer without going through the brief. Milord,
We don't have the brief.
Kindly allow me 2 days time. That
Very
day.
well. On the prayer of the appellant, let the matter stand adjourned. Sorry, till April 21,
Alhamdulillah.
2025. 21st April, please come back. Whatever documents you rely on, please give an inkling to Mr. Mitra. Plain injunction application, you have to have copies on the next day, 2 copies for the judge.
Right. But I have already annexed. Xerox. I have not annexed. I have Xerox. Keep ready to hand over my lord and also my learned friend. I have already Xerox.
1500 pages then. 500, 500.
No, only plain without annexure I have Xerox. Without the annexures that too.
Very well.
Well, I will take all these points.
Annexures of either the plaint or the injunction application have to be given to us.
Right.
আচ্ছা কোনটাতে অ্যানেক্সার আছে সেটা বললে প্রিন্টেড পিটিশন কোনটাতে ঠিক আছে
Mr. Mitra, you bring all the plaint as well as the injunction application.
I will bring earlier one also over the present one. There are 2 injunction applications.
Let us start with the present one. We'll
I will.
over the course of the hearing, over days, we'll.
Well, I will hand over to my learned friend and also Milord, my lord.
Thank you.
So I have.
Let us come back on 21st then, next month. Yes.
Sorry to disturb for paying time. Milord, I should not.
No, no, no. Why should you be sorry for?
But I got 2-3 cases today, so I could not prepare myself.
Before some different court.
in some other courts, my lord, which was.
Oh, you are giving preference to other courts over this?
No. Before research, it was taken before Chief Justice.
Then we don't know what to do.
So I could not prepare myself. I am
So
convinced.
we'll be very strict on the next day. That much we can.
Your lordship knows my adversary.
No, I know him, but what does that? No, Mr. Bitru is not so intimidating sort of person. I mean,
I have to be
he
prepared.
intimidates differently by his arguments.
Lord can pat. I am not a such a
That's
big
enough, my lord, to
You're
intimidate
sufficiently
anyone.
handsome for that, but
It is
but
my fault.
Mr. Mitri intimidates through his arguments, not through his presence. His presence is very pleasant, but during arguments, he intimidates through the arguments.
That's true.
21st, please bring all the documents, the plain injunction application at least. Written objection ফাইলই করেনি লর্ড এখানে সব অ্যানেক্স কোচের কাছে যেগুলো গন্ডগোল আছে হ্যাঁ হিয়ারিং 5 minutes taken. You are rising because in 5 minutes no hearing will be completed. হ্যাঁ সেদিন কি বলেছিলাম ভুলে গেছি কারা ছিল উকিল কারা ছিল ওইটা হিয়ারিং লিস্টের টপের হিয়ারিং লিস্টের টপের হ্যাঁ হিয়ারিং লিস্টের টপের